Therefore, adjournment is pending. From item number 1 to 3. From item number 3 to 12. From item number 13 to 22. From item number 25 to 30.
May I please your lordship?
Yes.
Lordship, I beg to mention item number 16, lordship.
16. What do you want, madam?
My senior counsel is out of station for his further illness. Kindly adjourn the matter.
Counsel MS so and so states that arguing counsel Mr. S.B. Laskar
Yes, Lord.
is not available today on account of some personal difficulty. Prayer is made to adjourn the matter. List after summer vacation.
Obliged, Lord.
May I please, the lordship? I beg to mention item number 29.
What happened?
With the consent of the other, I am for the respondent, your lordship.
There is a writ appeal of 2019.
Yes, your lordship.
Why do you want an adjournment?
Due to some personal difficulty, lordship.
What personal difficulty, sir? All right, and counsel for the appellant submits that he is not prepared to argue the matter, states that he is not prepared with the matter and request for an adjournment.
Lordship, I am for the appellant in this.
You are
matter.
for the appellant.
Lordship,
What do you say? You have any objection?
we have some personal difficulty. How can
All
we
right.
take-
For the respondent, लिखिएगा. Counsel for the appellant does not object to the prayer. Thus, list after summer vacation.
May I please, your lordship? I would like to withdraw item number 25.
25. And counsel for the petitioner craves liberty to withdraw the writ petition, hence the same is disposed of as withdrawn.
Obliged, one. Oh.
May it please, lordship. Well, I beg to mention item number 32, my lord.
32.
32.
What happened?
Well, here, well, Mr. R. Mozumdar, he's appearing, my lord. Today is not available, my lord. And I have taken consent of the
Appear, you are for the respondents.
respondent, my lord.
Mr. Katni are appearing for Mr. R. Mohanta
R. Mozumdar, my lord.
or Mazumdar.
Yes.
Submits that. Double AG. R. Mazumdar.
R.
Submit that. And standing counsel, Mr. R. Mazumdar is not available today. Prayer is made to adjourn the matter. The other side is no objection. List after summer vacation.
Obliged, lordship.
May I please, your lordship? I would beg to mention item number 26. For this, with the consent of the other side. Mr. R. Mazumdar is leading this case. Since he's out of
It is
station.
stated that Mr. R. Mazumdar, double AG, shall be arguing the matter on behalf of the appellant. He is not available today. Prayer is made to adjourn the matter. List after summer vacation.
Much obliged.
May I please, your lordship?
Yes,
Therefore, listing lordship, a read appeal lordship for withdrawal lordship.
for withdrawal
Yes, lord.
tomorrow. Tomorrow.
Daily list for orders, item 1 and 2.
Manoj, this is that matter, Manoj, regarding implementation of the provisions of the Juvenile Justice Act, Manoj, in
Yes,
terms
yes.
of the judgment, Manoj.
Yes.
And as I mentioned, Manoj, this is a matter. Manoj, may kindly see it's completely non-adversarial or lordship.
We know now. We have a proposal.
Yes, Manoj.
All right. We have recently reconstituted our Juvenile Justice Committee.
Right, Manoj.
In Rajasthan, what we had done was that the suo motu PIL, which was registered for looking out at the complete overhaul of the juvenile justice system, that was assigned to the bench comprising of the members of the JJ committee.
Yes, Manoj.
So they have a sync with the entire system.
Absolutely.
So we propose to do that.
Yes, Manoj, just one small thing, Manoj.
On the last date, probably we made a query
Yes, Manoj.
regarding the
UNICEF, Manoj.
funds, UNICEF and funds of ICDS.
But I have prepared an affidavit on behalf of the State Child Protection Society Assam. But in the judgment of the Honorable Apex Court at para 95, so many directions are there. But from this particular authority, I have got response in respect of some, and I have prepared an affidavit. We are filing it. That fund, they said that fund is not. They have said that it is not available with them.
That is a centrally sponsored scheme. It is provided to every state.
Correct.
You have to search more.
Lordship.
Those funds are lying unused in every state across the country. And they don't lapse, luckily. They remain alive.
Lordship,
And so if these funds are available,
my lord,
reappropriation for a fruitful use,
lordship,
so as to improve the system, will be very relevant.
lordship,
That's what we are telling you in Rajasthan.
lordship.
We requested the state to reappropriate, and in that manner, we could manage to put in place an entire facility for providing training to the CNCLs,
In fact,
CNCPs rather.
Rajasthan then, my lords, with my little experience across the country, my lord, would be the only state which has done that. my lords. It's a very nice suggestion, my lords. I think the state should poke the right buttons, my lords.
But the issue is that they have to come out with that statistics.
Correct.
And we had requested the UNICEF people
A representative from UNICEF is there.
is there, all right.
Yes.
So once we assign the writ petition to the special bench,
Yes.
the bench will take it up on
Fine.
periodic basis
Fine.
and supervise everything which is being done.
My lords,
The
this
only
one,
one aspect, my lord, regarding this ICDS scheme,
Mm.
as has been, my lord, said by the UNICEF representative.
You can
My
come
lord,
forward
the
and,
name of the scheme has been changed now. It's Mission Vatsalya.
okay,
The
maybe
entire
that
new
might,
Scheme has come, my lord, same purpose, my lord.
yes,
with
but
some
the
additional-
funds of the earlier scheme,
Yes.
they don't lapse,
They don't-
basically.
they don't like-
He can come forward and tell us.
Yes, yes.
Let's have what he is having in hand.
Thank you so much, sir. Sir, in 2022, Government of India has changed the nomenclature of the scheme from
Oh.
ICPS to Mission Vaschalya.
Okay,
So in Mission Vaschalya, again, they are following the same pattern, 90,
okay.
10%.
This is the reason probably, Mr. Nath.
My lord, that mission Bachelor is going on, funds are coming and it is being utilized for under.
Total
various-
funds are not being utilized, rest assured.
I'll get
Uh,
the details, my lord. I'll get. the-
Mr. Lakshminarayan, representative UNICEF is present.
my lords,
Yes.
if Lordship doesn't mind, my lords, just one small, I'm so sorry to
No,
interject.
please tell us.
Lordships will just see the order of the 31st of March for a moment, my lords.
31st March.
Difficulty is, my lord, there are several components, my lords, which are not complied with, like a
Hmm.
audit. My lords, there is no policy as far as the state of Assam is concerned.
That's
Well,
what we are saying.
So
Mr.
therefore, my
Counsel.
lord, that direction may be given when the matter comes up next before the special bench, my lord. Let that affidavit as per your lordship's direction.
Now,
on the
of
31st.
of course, he's already indicating that he's in the midst of preparing the
Very well,
affidavit.
very
It
well.
will come up.
Lordship,
The state protection society, child protection society, there's affidavit is required. It is ready, my lord. We are filing it today. And from the other authorities, because so many facets are there, other authorities are involved. my lord.
That's right.
Affidavit from them also, my lord.
Hmm.
It is under process, my lord. We will file it. We'll file it.
So there are two PILs. The one is for that vulnerable witness,
No, my lord.
Mr. Das.
One is the suo motu petition.
Yes.
The other is the petition PIL filed by me.
Okay.
That concerns not only Sampurna Behoria, which is in the suo motu,
Hmm.
but I have covered certain other aspects, my lords, which are being done across the states in the country, my lords.
All right. Okay.
Those are 4, 5, and that affidavit to which they are filing response covers everything.
All right. Mr. Lakshminarayan, representative UNICEF is present. He has pointed out that the earlier scheme of the central government, which was under the name and title of Integrated Child Protection Scheme, has now been redesignated as Mission Vatsalya. Mr. Nath shall take instructions as to whether the funds sanctioned in the previous scheme are still available and are lying unutilized and can be put to appropriate use for furtherance of the cause of the juvenile justice system in the state of Rajasthan, Assam. Full stop. Detailed affidavit as directed to be filed on 31st March 2023 is still awaited. Mr. Nath submits that he shall be filing the same today.
One part.
He shall be filing a part of these details
Lordship.
in form of an affidavit today.
Lordship.
Full stop. In order to give impetus to the overall development of the juvenile justice system in the state of Assam, we hereby direct that these two PILs shall henceforth be specifically assigned to a special bench which shall be constituted by members of the Juvenile Justice Committee, chairperson and member of the Juvenile Justice Committee, Assam, Guwahati High Court. The registry shall take necessary instructions for listing of these petitions.
Your lordship fix, I come from Delhi, my lord. If lordship fixes a date, it is convenient.
It will come up in July.
Very.
Before that, it will not come up. That's
Very.
for sure.
Well.
Or maybe we can request the committee to take up a preliminary hearing first.
Yes.
Before that, what will be the convenient date?
Any date, my lords, in June, it's definitely no problem.
So we'll indicate, we'll let you know.
Very
We
well.
just ask the master.
Very well.
Once
Great.
we form the bench, then we'll let you know.
Yes, I'm so great.
Mr. Lakshminarayan shall keep in coordination with amicus curiae, Mr. Nath, for further proceedings of these two petitions. We'll maintain coordination.
Item number 3.
Lordship, in this matter, we have filed the.
Yes. Yes, in this matter.
Lordship, in the both the IS lordship, we have filed the affidavit today only, lordship.
Just now I have received a copy of it.
Affidavit.
Yes.
In which matter?
In the IS
IAS,
lordship.
in
impleadment
IAS.
of both the
Learned
parties,
Government
lordship.
Council, Senior Government Council. MS Bhattacharya submits that she has filed affidavits in both the IS today. Copies thereof have been provided to Mr. Learned Council representing the petitioner who prays for and is granted.
As per your lordship's convenience, your lordship.
No,
2 weeks, your lordship.
2 weeks time to complete his instructions. List after 2 weeks.
Deeply obliged.
Obliged.
Item number 4.
May it be the lordship.
Yes.
May it be the lordship. Lordship, on the last occasion. Yeah, in this case, we were directed to make dusty service upon the respondent.
Yes.
So for instruction is received, my lord, we have dusty service upon 3 of the respondents and 3 of them has refused. So in that regard, we need to file the affidavit.
Learned Council for the appellant prays for and is granted 10 days time to file affidavit in proof of dusty service. List up to 2 weeks.
Item number 5 and 6.
May it please, my lords.
Yes.
My lords, this is the anti-dumping matter, my lords. Now, in this, my lords, I have moved an application for leave to appeal before this, my lords. And I argued this a bit, my lords, and I would frame 2 questions for your lordship's consideration. My lords, the first question would be as to whether I can be a party, my lords, in these proceedings, and whether I'm capable of filing a writ appeal against the impugned order.
Yes.
Well, the first question or first proposition is whether I'm an aggrieved party, my lords,
Yes.
because it is a person aggrieved who can file an appeal. Secondly, your lordships had pointed out last occasion the order whereby, my lords, my application before the single judge seeking to be a party, my lords, was denied, and I was made an intervener.
Intervener.
There, the learned single judge held that I do not have a legal right, but I nevertheless have a right, and therefore impleaded me, my lords. So the next question, therefore, would be, my lords, do I, my lords, as a company, my lords, get out of the term, my lords, aggrieved person merely because I was an intervener in the before the single judge, or, my lords, a fresh cause of action arises based on whatever judgment has been pronounced by the learned single judge, my lords, and I'll address this.
Yes.
Well, the first question is, am I an aggrieved party, my lords? Now, for that, we have to understand, my lord, what the learned single judge has said here, my lords.
Yes.
Now, the learned single judge, my lords, has held that the confidential information that I give, my lords, to the DA is to be disclosed to the other party, my lords. Now, that is completely unheard of as far as Indian jurisprudence is concerned, and as well as international jurisprudence is concerned. May I explain why? Well, as the anti-dumping jurisprudence in India is completely based on the GATT agreement or the GATT treaties. Well, as Article 6 of the GATT treaty says, well, and I'll show judgments also to that which extract all of that, that confidential information which I supply to the designated authority, my lords, cannot be disclosed, my lords, to a competitor, my lords. And the single judge holds contrary to that. Rule 7 of our rules, my lords, the Indian rules, also has a, my lords, similar corresponding provision in the Indian statute.
Yes.
My lords, for the single judge to say that my information is to be given to them, my lords, is a complete error, my lords. And my lords, these are information, my lords, these are, my lords, my right to privacy or privacy of my data and information is being asked to be given to the other side, which will be thereafter used by them, my lords, against me, which is the domestic industry, my lords. So therefore, I am definitely an aggrieved party. Maybe I was not an aggrieved party earlier, my lord, and therefore the single judge probably was right, and I did not file an appeal against that order, my lords, making me an intervener.
Yes.
But the right accrues to me as an aggrieved party, my lords, pursuant to the single judge's order, my lords. May I, my lords, take your lordships to a couple of judgments to make this good, my lords. There was a judgment, my lords, first of Sterlite, my lords, which clearly indicated, my lord, this is a judgment, my lords, of a division bench, which said that confidential information need not be given to the opposite party or the other party. That's because it's my information. Give me a copy.
Yes.
My lord, then came Reliance. I'll show that, my lords. My lords, kindly see para 3 of this, my lords. This is a bench of 2. May I read para 3, my lords?
Yes.
In our view, it is not necessary for us to get into the merits of this matter, as we propose to send the matter back to CGAT after laying down certain guidelines. From what has been argued before us, it appears that in pursuant to Rule 7 of the Customs Tariff so-and-so, the designated authorities treating all material submitted to it as confidential merely on a party asking that it be treated confidential. In our view, that is not the purport of Rule 7. Under Rule 7, the designated authority has to be satisfied as to the confidentiality of the material. Even if the material is confidential, the designated authority has to ask the parties providing that information on confidential basis to furnish a non-confidential summary thereof. If such a statement is not being furnished, then that party should submit to the designated authority a statement of reasons why summarization is not possible. In the event under Rule 7.3, the designated authority can come to the conclusion that confidentiality is not warranted. It may, in certain cases, disregard that information. It must be remembered that not making relevant material available to the other side affects the other side as they get handicapped in filing effective appeal. Therefore, confidentiality under Rule 7 is not something which must be automatically assumed. Of course, in such cases, there is need for confidentiality, as otherwise trade competitors would obtain confidential information which they otherwise cannot get. But whether information supplied is required to be kept confidential has to be considered on a case-to-case basis. It is for the designated authority, this is very important, it is for the designated authority to decide whether a particular material is required to be kept confidential. Even where confidentiality is required, it is always be open for the appellate authority, namely Sextat, to look into the relevant files. May I just pause here for a moment, my lords? My lords, in this, the facts of the particular case, my lords, I said certain information is confidential. I gave a summary of the entire confidential information so that they are not prejudiced, my lords. The DA, in the final finding, comes to a conclusion that yes, this material is confidential and you're not entitled to it, and therefore comes to the dumping margin, my lords. My lords, therefore, the DA has taken a conscious decision, and that is also recorded in the impugned order. I'll show your lordships that also. Now, my lords, this and Reliance came up for consideration before a full bench of the Honorable Supreme Court, my lord, a bench of 3 in Make Money, my lord. Make Money. आप दीजिए कॉपी से. 150. My lord, lordship sees, my lord, page 159. My lord, GM Exports is the first one. My lord, GM Exports, my lord, says it's a judgment of Justice Nariman, my lord, which says that international conventions, Indian law has to bow down. Wherever there is a gap in the Indian law, my lords, it has to bow down or borrow from whatever the international law says. My lords. But my lords, why I'm relying on GM exports is to basically canvass the point that Rule 6 also specifically provides and specifies, my lords, that confidential information cannot be passed on, my lords. Only to that extent. Make money, my lords. Your lordship sees there is a big page number at the top of the page, my lord. Yes. At 159, and then your lordship sees para 5. This judgment, my lords, gives the broad contours, my lords, of Rule 7. So if your lordships permit, may I just quickly read 2 paragraphs? Well, I'm grateful. My lord, para 5. With a view to place Rule 7 and other relevant rules in the correct perspective, we have been taken through section 9A, B, and particularly subsection 2 of 9B of the Act. Section 9A clarifies as to when an article exported from any country or territory to India at less than its normal value may be subjected to an anti-dumping duty, not exceeding the margin of dumping in relation to such article. By the
merits of the controversy.
I beg your
This what you are reading is on the merits of the controversy.
Yes, my lord.
But right now you are only arguing on the aspect whether you are required to be, you deserve to be given permission to file an appeal.
Yes, but for that, as I said, my lord,
Yes.
unless and until I demonstrate, my lord,
Yes.
that the finding is wrong and completely prejudices me, my lords.
Yes.
My lord, how do I show my lord, that I am an aggrieved person? Well, only to that limited extent, my lord.
Yes.
By the aid of explanation, margin of dumping has been clarified as the difference between the export price and the normal price of an article. The meaning of export price and normal value requires some factual investigation to find out whether dumping has taken place or not. If yes, what is the margin of dumping? Therefore, section 6, subsection 6 of 9A not only authorizes the central government to ascertain and determine after necessary inquiry the margin of dumping, but also empowers it to make rules for identifying articles liable for anti-dumping duty and the manner in which the export price, the normal value, and the margin of dumping in relation to such articles need to be determined, as well as assessment and collection of such anti-dumping duty. Section 9B states the circumstances and situations when an article shall not be subjected to countervailing duty or anti-dumping duty under section 9 and 9A. However, subsection 2 of section 9B empowers the central government to frame rules under which an investigation may be made for the purposes of 9B to meet exceptional situation contemplated by 9B1, small b, small Roman 2. Para 6. The central government frames so much. To cut the controversy short, this last sentence of para 6, Lordship sees Article 6 there at the bottom of the page. Article 6 deals with evidence, which is generally to be made known to all interested parties, except when the information is confidential. Paragraphs 2, 4, 5, 8 under Article 6, shown as paragraphs 6.2, 6.4, 6.5, and 6.8, have ample connection with the matter at hand, and hence they are extracted below. These are the provisions of the GATT agreement. The Lordship will take it from me, that the GATT agreement, it's mutant, completely paramateria as far as the Indian jurisprudence, as far as this aspect is concerned. Now the conclusion, the Lordship comes to the conclusion at para 25, at page 165.
Yes.
In the light of the facts and submissions noted earlier, as well as conclusions already recorded at various places, we are of the considered view that the question referred for our answer can be answered in a very straightforward manner by holding that Reliance Industries case did not go into the details of the relevant rules, including Rule 7, but the observations made therein in respect of the rule of confidentiality as spelled out in Rule 7 of the rules does not diminish the scope of Rule 7 as provided. The reasons or findings cannot be equated with the information supplied by a party claiming confidentiality in respect thereto. Hence, Rule 7 does not empower the DA to claim confidentiality in respect of reasons for its findings given against the party. The law laid down in respect to the rule of confidentiality in such Sterlite case, which I read to your lordships, also has our respectful concurrence. But at the same time, we reiterate that Reliance Industries does not adversely affect the case of the concerned parties, run counter to the law spelled out in Sterlite case. We may only explain here that while dealing with the objections or confidentiality of by duly accepting such a, we may explain the case of the concerned party, the DA must not disclose the information which are already held by him to be confidential by duly accepting such a claim of any of the parties providing the information, while taking precautions not to issue so that the parties may in general terms have the knowledge as to why that case or objections has not been accepted in preference to a rival claim. But in the garb of unclaimed confidentiality, the DA cannot shirk from its responsibility to act fairly in its quasi-judicial role and refuse to indicate the reasons for its findings. The DA will do well to remember not to treat any information as confidential unless a claim of confidentiality has been made by any of the parties supplying the information. And I did so in this case. In cases where it is not possible to explain a claim of confidentiality, Rule 7 hardly leaves any option with the DA but to ignore such confidential information if it is the view that the information is really not confidential and is still concerned and still the concerned party does not agree it to be made public. So, my lords, the test laid down is, my lords, if I say that the material is confidential and the DA comes to the conclusion, my lords, it is not confidential, I'll supply it. The option is with me to decide whether I want that information. If I say that I do not want that to be disclosed, my lords, an adverse inference may be drawn, my lords. But to say that that information has to be given to the other side is completely unjustified and completely wrong, my lords. And that is concurred by Sterlite as well as, my lords, make money, my lords. My lords, now Rule 7, what does Rule 7 say? My lords, two pages before that at 162, the Rule 7 is extracted, my lords, for your. May I quickly read that for your lordship's benefit?
Yes.
Rule 7, notwithstanding anything contained in Rule so-and-so, 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 the copies of applications received under subsection 1 of Rule 5 or any other information provided to the designated authority on a confidential basis by a party in the course of investigation shall, upon the designated authority being satisfied as to its confidentiality, be treated as such by it, and no such information shall be disclosed to any other party without specific authorization of the party providing such information. My lords, that is all, my lords. My lords, so, my lords, as far as I am concerned, I am aggrieved by the order passed, my lords, by the learned single judge, which says that natural justice demands that I have to give the confidential information to the other party. That is my appeal before your lordship, against which I seek, my lords, a leave. My lords. My lords, my learned friend raises an objection saying that, my lords,
Don't preempt his arguments.
my lords, yes, it is his argument, my lords, and he's
Don't preempt his arguments.
Yes.
Let him raise the argument. You will have a chance to offer rejoinder if it's
very
required.
well. But let me place the point, my lords,
Yes.
because the query came from your lordships, my lords, because your lordships pointed out the order of the learned single judge, which, my lords, held that I do not have a legal right, but
Yes.
I only have a right as a impleader or as a necessary party maybe, but not a proper party. The argument to that is, my lords, as I said so earlier, that my right
Was created the moment the direction was given to divulge the information.
correct, my lord. That is my
You
cause of
already
action.
argued that.
I'm
yes.
so grateful, my lord. And my lords, on the counter, I have a couple of judgments, my lord. Let my learned friend raise that point. I'll counter that, my lord. Clear law, my lords, that an intervener, my lords, can also file, my lord. I'll straw.
My lord, I will summarize my argument 4 points.
Yes.
First, whether intervener has the right to file an appeal or not.
Yes.
Now, my lord, this has been settled by the apex court in judgment. I come to that, Miller, whether because he has aggrieved by part of the order, whether that order, then a single judge directed the confidential information be furnished or not, that I will show, Miller. You'll also see the para 2, Miller.
Now, this judgment is available on file.
I need a copy. I've given a copy.
In Sweden.
What
There's
is
a copy.
this? Yeah.
I will give you
That's
copy.
it.
Courtesy.
Give a
There's no
copy.
system of giving
But
copies.
I have given you this.
You may give, but we don't have the system.
What happened?
He said
Malad-
that why the copies have not been. given to
Malad,
judgment.
that custom should be here also, Malad,
No, but
exchanging
that
copies.
may be
Malad.
system in Delhi, but Guwahati, the system is not there, but we'll provide you
This
copies.
is a, Malad,
No, this is not the courtesy.
Malad, this courtesies are always supposed to be
You
built up.
can at
Malad.
least
We are
state the
giving copy.
citation.
We'll give the site, not the
You
citation,
just-
provide the copy also.
Malad,
You
and,
just
and to
state the
this, Malad,
citation, Dr. Saraf. You
Malad,
can state the citation.
And give me the
There's no
citation.
problem in that.
Malad,
And just
to-
after reading it, Miller, I'll
and
provide
to
copy.
Malad enrich the High Court, Malad, this courtesy should be adopted, Malad, rather
Our
than
High-
Malad
our High Court is
getting
much-
away from it, Malad.
Much better than other high courts.
Of course,
Please
I have
don't-
no doubt
don't-
about that.
Don't say that I want to enrich the high court.
Dr. Saraf, please provide the citations in advance. There is no harm.
Miller, I'm,
Yes.
since I'm giving, Miller, I'm trying to find out copies also. Generally, we provide compilations also. Miller.
Or you give our set to him. We have got an extra copy in.
No, Malad, it's okay.
Okay. Yes.
So it says, Miller, it seems to us, para 2, Miller, I'm reading,
Yes.
that the intervener is not entitled to appeal against the judgment and order of the High Court, and the High Court should not have granted certificate to them under Article so and so. In such cases, the other officers who intervened before the High Court should, if they wanted to be heard, have applied to the Supreme Court for intervention in the appeal filed here.
There is no appeal. So where they would intervene now?
Well, I'd say, Miller, our appeal is there, they can intervene. Our appeal is there.
Okay.
Now I may give to the Lordship the judgment of the Bombay High Court, Miller. Para 12, Miller. This is Primarily, it is obvious that this LPA is filed by intervener and it cannot be disputed. The intervener in the petition has only the right to address the court. He cannot take active part in the proceedings. As contended by learned counsel for the respondent one, the appellant cannot prefer this appeal, and he has in fact no locus to challenge the impugned judgment and order. It is difficult to disagree with the learned counsel. It would be seen that the repetition from which
That
the
was
impugned order
appeal,
arises-
rejection of the appeal because there was no right. Now they are seeking leave. It's a different
Well, the-
contour to this controversy.
Right,
now.
subject,
Yes.
seeking leave and when he has no right.
That-
It is doing the same thing from the backside. If he has no right to file appeal at all,
Yes.
then seeking leave also, it will amount to my lord the filing appeal. In fact, he filed the appeal first, it was numbered, thereafter he is filing an application for seeking leave. Well, I'm placing the judgment. Now I'll come to the arguments which he has advanced also.
Yes.
Now he said agree party.
Mm.
Now you'll also can see some of the judgments on the agree party.
So first, let us be clear on this aspect that the learned single judge has directed
You'll
the
also see-
confidential information to be
that will-
divulged.
that
That
will
is the
better.
fact.
That will be better, Milord. And Lordship may once note one more point, Milord, that this judgment was subject matter of review and the review was allowed
Review
by the learned single judge. The
who
judgment.
filed the review?
My lord. My
Who
lord,
filed the review?
we filed the review.
You filed the review. Okay.
And the review was allowed on certain points. Now that review is not under in the challenge. He says that we are not concerned with the part of the judgment which was in the review. but
They are aggrieved only to the extent they want to file an appeal only to the extent the disclosure of the information was ordered.
in the appeal, they have placed many points. If he says that other points I have given, the points are not there, then I take it that Milord, that the writ appeal is only limited to the confidential.
That was what was argued.
Milord,
Let us know.
Say that it's only limited.
Do
to
you
the-
reserve your challenge only to the aspect?
Only to that aspect,
Yes.
and I'll demonstrate all
No, no.
other issues are infructuous.
No, no,
I'll
I-
demonstrate them.
We are not bothered to go into that aspect if
Correct.
you are limiting
No,
your arguments to
I'm
that.
limiting it.
All
to
like
that.
Dr. Saraf, what do you say?
I'm limiting it. to that.
So I take
To
it
that
that-
extent,
My lord, that is.
we can grant him a limited permission,
My lord,
file an appeal, then
if you are
test the judgment on that.
If you are
aspect.
convinced, Milord, that the learned single
see,
judge is directed.
You see, Dr. Saraf,
My lord.
this is a subsequent appointment.
No, if-
Till he was an intervener.
No, I'm saying that learned single judge passed, judgment. If learned single judge has said that confidential information should be passed,
Let's see that. All
then
right.
your lordship may
Yes.
see.
All right. Let's see the judgment.
Before the placing the judgment, I may tell you lordship, Milord, that anti-dumping duty is calculated on the basis of the non-injurious price determined by the designated authority on the basis of the materials furnished by them. Now that is a calculation that this is the figure of non-injurious price, this is the figure of normal value. Now what the learned single judge said, he says only provide the figures. You lost me, can you see? My lord, at page 548, it starts from 546, my lord.
Para.
And para, I'm taking lordship to para 118.
Yes.
I'm reading, my lord. For the purpose, when we look into the provisions of ADR rules, we take note of Rule 7 and has been interpreted in paragraph 43, 44, 45 and above. The conclusion of such interpretation is that the provisions of Rule 7.1 is not declaratory in nature, and on the other hand, it is enabling provision by which any information provided by the domestic industry, their application under the rules so other interested party can be claimed by be confidential, subject to the satisfaction acceptance of such confidentiality by the designated authority. Rule 7.1 does not provide that the entire application of the domestic industry under rule so and the information contained therein state may become confidential information merely because the provision rule 7.1 had been invoked. Only such portion of the information which the designated authority certified to be confidential are to be treated as such. Further, Rule 7.2 provides that the designated authority may require the party providing information on confidential basis to furnish a non-confidential summary thereof, meaning thereby for such confidential information, again Rule 7 to provide that notwithstanding anything contained in sub-rule 2, the requirement of providing a non-confidential summary of the confidential information, the designated authority is satisfied that the request for confidential is not warranted or the supplier of the information is either unwilling to make the information public or to authorize the disclosure in a generalized summary manner, the designated authority may disregard such information and not take into consideration for the purpose of determining normal value so and so. This is the provision of the rules. Now we'll also see from the provisions of Rule 7 as a whole, it will be difficult to accept the stand taken by the designated authority that even the normal value, export value, margin of dumping, and the non-injurious price as determined would be confidential. What is he said will confidential? The figure which has been determined. If the figure is not provided, my lord, like assuming non-injurious price, they say that we will not disclose. Normal value will not disclose. But anti-dumping duty has been determined at $500. Now, how the person concerned will come to know that how the $500 have been determined? So the single judge has not said anywhere that you provide the confidential information. You also see further. As because the same are based upon the information provided by the interested GFC, who is the domestic industry, and therefore it cannot be disclosed, even to the extent that it cannot be disclosed to the court. We also, so he said it cannot be disclosed information. We also arrive at such conclusion as because the material which has been produced by the domestic respondent industry, the designated has arrived at the satisfaction upon claim for confidentiality being made by the domestic industry that the entire information provided in their application so-and-so are confidential. It has also not been brought to our record that upon such satisfaction as regards confidentiality, the domestic industry was required to submit a non-confidential summary of the confidential information. It has further not been brought to a record that the supplier of the information is either unwilling to make the information public or to authorize its disclosure or generalized or summary form. In the circumstances, under the provision rule 7.3, either the information provided by the domestic industry is to be disregarded or they are to required to be provided the manner laid down in 7.3. Now the direction you'll also see, para 123. Accordingly, reading the whole of the provisions rule 7, including rule so-and-so and the provision so-and-so, we are of the view that the stand taken by the designated authority as well as respondent that the normal value, export value, margin of dumping, and the non-injurious price arrived at the final findings are confidential in nature. The Melon single judge not said that you provide the information furnished by the domestic industry. The non-single just said, you provide the figures which has been determined. If the designated authority says that $1,000 is the anti-dumping duty.
Mm,
Now that has been determined on the basis of normal value and export value and the energy price.
mm.
If that figure is not given, how the person concerned can challenge the finding of the authority?
Mm.
Nowhere in the finding will it say that confidential information which has been provided by the domestic industry is to be furnished.
Mm.
The learned single judge has taken note of all the provisions and said, my lord, those who are claimed to be confidential, they cannot be disclosed. Those who are claimed to be confidential, if the designator finds that no, this is not confidential, disregard it. That is the provisions of the rule. Learned single judge has not at all said that you provide
Complete information.
whatever company seems to be again. But if the figures are not given, my lord, and anti-dumping duty is imposed, the reason I'm telling you, lordship, my lord, earlier also such figures were provided by the domestic entity, same, my lord, the applicant. So after 5 years, on the basis of those figures, anti-dumping duty was imposed. After 5 years, when the review was made, the designator actually found that all the figures were wrong.
Mm.
And thereafter withdrew the anti-dumping duty which was imposed. So, my lord, only for the purpose of looking at that whether the anti-dumping duty had been imposed on the basis of the difference between non-injust price and normal value, and what is the figure conclusion? If the conclusion is also not given, can it be said, my lord, the conclusion which has been arrived at the figures, the figures what are given, my lord, star, star, star. Now, how the person concerned will come to know that this is the star, star? Now, we say that that amount which has been determined, that should also not be disclosed.
Mm.
That is also confidential.
Right.
I can understand, my lord, that the information which they are providing, in fact, the information which they are providing are available on the website of the company. All the sales, all these figures are provided in the accounts and all the similar audit. Don't ask for, we have got the copies from the website itself.
Mm.
Why we should ask for the information which are available in the website itself?
Mm.
But the figures which have been determined by the designator for the imposition of the anti-dumping duty,
Mm.
if they are not informed, then, my lord, the basis of the imposition of anti-dumping duty itself will become arbitrary, because that will be arbitrary exercise. Nobody knows. He can impose any duty.
Mm.
So, if by reference can show anywhere from the judgment of learned single judge that the confidential informations were directed to be furnished, I can say that, my lord, yes, he has agreed because the learned single judge has directed that confidential information should be furnished.
Mm.
Learned single judge has only said that value of the normal value, export value, and that has been determined. That figure should be given, not the information which has been provided for at all. Now, if this is so, my lord,
Yes.
then how it can be said that the learned single judge director's confidential information, the other competitors will, my lord, get benefit of it and will have the information? No. In fact, whatever information we are providing, that is available in the public.
Okay.
So, my lord, learned single judge has gone by the rules only and has simply said, my lord, that it will be arbitrary exercise of powers. If the any duty is imposed on me, my lord, by way of that you have to pay some amount of tax on the basis of determination, and the determination is not said. As income tax, my lord, I'm saying, they don't say that this is your income, and they say that you are liable to pay 5 lakhs income tax. I say, how, on what basis? They say that I will not disclose. Very confidential. Can it be said, my lord?
Mm.
Can it be said the basis of determination, the calculation part, that has to be given?
Yes.
There's no disclosure of information of the domestic industry. Now, the lordship kindly see, my learned friend was saying about the aggrieved.
Yes.
Lordship see page 8, my lord.
Yes.
In the just from the 10 or 12 lines from bottom, it is said.
Mm.
Has your lordship got it?
It is said that any
Well, it
person
said
agree.
any person aggrieved by an order of the court is entitled to appeal. But the words person aggrieved do not really mean a person who is disappointed of the benefit which he might have received if some order has been made. The person aggrieved must be a man who has suffered a legal grievance, a man against whom a decision has been pronounced, which has been wrongfully deprived him of something, or wrongfully refused him something, or wrongfully affected his title to something. Now, you'll also see page 36. at the bottom, my lord. Person aggrieved. It is a settled legal proposition that a stranger cannot be permitted to meddle in the proceedings unless his certified authority hold that he falls within the category of aggrieved person. Only a person who has suffered or suffers from legal injury can challenge the etc. I'm sorry. Thereafter, Lordship may skip over 2-3 lines, my lord. A copy this.
Page number.
Therefore, there must be a judicially enforceable right available to the enforcement of the basis of which this jurisdiction is resorted to. The court can, of course, enforce the performance of its statutory duty by the public body using the jurisdiction at the behest of the person, provided that such person satisfies the court that he has a legal right to insist on such performance. The last, my lord. In fact, the existence of such right is the foundation of the exercise of the jurisdiction of the court. You also may skip over para 10. A legal right means an entitlement arising out of the legal rules. Thus, it may be defined as an advantage or benefit conferred upon a person by the rules enforced. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. Now we'll also may skip over, may come to page 63.
Yes.
Where 37 below. It will be seen that in the context of local study to apply for a writ of cessionary, an application may ordinarily fall in any of these categories. Person aggrieved, stranger, busy body or middleman or interpoloper. Person in the last category are easily distinguishable from those coming under the first two categories. Such persons interfere in things which do not concern them. They mosquito or casual for justice. They prefer to act in the name of the pro bono application, though they have no interest in the public or event of their own contact. They indulge in the passing so-and-so. Thereafter, often they are actuated by the desire to win the notoriety of the cheap popularity, while the ulterior intent of some application in the category may be so-and-so. We skip over, we come to para 19.
Yes.
To distinguish such applicants from strangers, among them, some broad tests may be reduced from the consequences made thereof. These tests are absolute and ultimate. Their efficacy arises according to the circumstances of the case, including the statutory interest in which the matter fails to be considered. These are whether the applicant is a person whose legal right has been infringed. Has he suffered a legal wrong or impurity in the sense that his interest recognized by the law has been prejudicially and directly affected by the act and omissions of the authority concerned of it? Is he person who has suffered a legal grievance of any person? Now 41, did the appellant have a legal right under the statutory provision in or that of the general law which had been subjected or threatened with injury? The answer in the circumstances of the case must necessarily be in the negative.
That was in the peculiar facts of that case.
My lord, if my learned so that there was a provision in the rules not to provide the information of normal value, export value, or non-use price. And in spite of that, the learned single judge has directed that yes, this information has to be furnished. I can understand that his legal right under the provisions of the act has been violated. But if the learned single judge says, my lord, that without this information, how a person concerned can know that how this anti-dumping duty has been determined, and this information, how it can be said that these informations are confidential? Confidential are the informations which are furnished by him. But the conclusion which has been derived at, the figure which has been derived at, that can also be well confidential. Then I know nothing. I have to pay the anti-dumping duty, but I know nothing. How it has been determined. How this figure has come up, I don't know anything. I have to pay whatever has been determined. I have no right to challenge also. If I challenge, there is no figures. So it cannot be said by any stage of imagination that the learned single judge is directed for furnishing of the confidential information which has been provided by the domestic industry so that the other competitors will be benefited. No. You also have seen the order of the learned single judge. The learned single judge nowhere said. Learned single judge analyzed all the provisions and whatever provisions are there that has been taken note of, only the figures which has been ultimately arrived has been directed to furnished.
Yes. Yes.
Now, on the ground of the review, my lord, even if assuming, my lord, my humble submission, that he is arguing, challenging one part of it. In my humble submission, the judgment after the review is passed, it merges, and that judgment no longer remains. He cannot challenge that judgment alone, saying that I am not challenging the part of it. No, no, that is not the law. Once the review order has been passed, it emerges, and that earlier order no longer remains. If the order no longer remains, how he can say that I am challenging only part of it?
Well, if he says that, I have no difficulty.
Let me
Review decides only 2 points. I will leave my appeal, no difficulty.
Let him complete,
Yes,
please.
yes. That is up to you to withdraw and file a case. I am not saying that you can do anything. This is one of the points, Milord, that the writ appeal, I am on the ground of maintainability of the writ appeal at this
Okay,
stage.
Saraf, if the review decided few points, are you giving up what the earlier directions were given? Have they become OCS?
No, no, the earlier directions which are there, the judgment gets merged.
No, that's
Milord,
all
the judgment
right.
gets
That's
merged,
all right.
Milord,
He is
by
aggrieved.
instance,
He is aggrieved by a particular part of the judgment,
Milord, with
not the directions given in review.
due respect to your lordship, Milord, subject to my limited,
It's a very hyper technical kind of argument.
Milord, the subject to limited my Milord, that when the judgment is no longer existence, Milord, it gets merges, whether on one part or other part. Then to say, Milord, that I challenge this part of the judgment only on the ground that, Milord, part of it, then your lordship will decide.
That he can amend the prayer. That's not a big deal.
Because my main
That prayer can be amended even now.
again, Milord, coming back again the same thing, so I am not mainly on that.
Yes.
My main points are that first, the intervener has no right, the Supreme Court said, and even
Yes.
if he says that Milord, after the judgment was delivered, he is a person aggrieved because confidential information the director furnished, that is not correct at all. And he is not a person aggrieved at all because no information has been directly furnished.
All right.
Well, he's raised 3 broad propositions or submissions, Milord. The first is that, Milord, I am not an aggrieved party. For that, he says that the High Court order does not have any finding, Milord, to state that I should disclose confidential information. 2, I am also not aggrieved because there is nothing in the rules. Milord, he also says, Milord, that if there is anything, point out something in the rules, Milord, that prohibits or that prohibits me from disclosing my confidential information.
Not the information.
Yes, Milord.
Counsel.
But keeping that information to me, Milord, and not disclosing it.
He doesn't, he never argued that. He said that the parts which have been directed to be disclosed are somewhat eschewable from the main information.
Correct.
These are the statistics based on which the determination has been made. So that is not the confidential information at all.
Correct.
That's what his argument
Very
was.
well. I'm so grateful, Milord.
So his argument is the rules do not prohibit that such information is also or do not provide
to be excluded.
That such information will also not be provided.
I completely bow down, Milord.
Yes.
My learned friend is, my lordship is absolutely right, Milord. I cannot say my learned friend is right here, Milord. Then he says, Milord, the right of the intervener, and for that, Milord, he relies on the Supreme Court judgment of Swine, Milord, and I will show how that is not applicable. Milord, coming first, Milord, to the impugned order, para 123 at page 550. I'll just read it, Milord. Lordships will not. This is a small paragraph. I'll just read that sentence. Accordingly, reading the whole provisions of Rule 7, including Rule 7.3 and the provisions of Rule 16 of the ADR, we are of the view that the stand taken by the designated authority as well as the respondents that the normal value, export price, margin or dumping, and the non-injurious price arrived at in the final findings are confidential in nature and it cannot be disclosed to anybody. So therefore, my lords, there need not be, my lords, an order, okay, please go ahead and disclose this information. But this finding, does it leave any scope for the designated authority, my lords, not to disclose?
Yes, he says that the determination is done on basis of these very figures and facts.
Lordships will clarify that. That part of it may be clarified. I have no difficulty then.
It's already there.
No, my lords, may kindly see, are confidential in nature and that it cannot be disclosed to anybody. Therefore, at any stage. So my submission is, my lords, and that is what.
Mr. Counsel,
yes, my lord.
do you dispute the submission that these very facts and figures were the basis of imposing the or determination of the anti-dumping duty.
Malad,
Without these facts and figures or these the values being available, the anti-dumping duty could not have been determined.
correct. Malad,
So if you determine anti-dumping duty on particular statistics and you say that the person aggrieved, he will not be entitled to know what is the foundation thereof.
correct. So the law.
How
what-
that information can be confidential.
Correct. What the law provides, my lord, and upheld across, my lords, by various authorities, Supreme Court, various High Court, my lord, is that two things, my lords. One, I am the master of my data, my lords, under the Constitution bench judgment, as far as Puttaswamy is concerned, my lord, that I will hold that this judgment or this data.
You can't be selective that I'll provide the data to the authority. But if that data adversely affects someone else,
Correct.
that has to be considered.
No, Malad,
No.
that decision, as per what Make Money also says and Sterlite also says, who's to take the decision? That decision, the master of decision is the designated authority. Malad.
Designated authority's decision was assailed in the High Court.
Correct.
So that was subject matter of judicial review.
I
If the
completely
decision was arbitrary, it has to be interfered.
correct, Malad. But what I'm trying to submit here, Malad, if the designated authority therefore had the right, Malad, to discard that
No,
information.
not the right, the
Malad,
jurisdiction.
Malad, the question is, Malad, question is, and I respectfully submit this, Malad, whether, Malad, the DA, if I have provided something, Malad, he may use it, he may not use it, Malad. If I have stated, Malad, if he wants to use the information, he
Yes.
can say, no, I deem it that this information is not confidential and I'll pass it on, Malad. So what is the procedure laid down? In that case, he has to ask me, Malad. I agree what is falling from your lordships, Malad. There's no difficulty. But, Malad, what I say here is that if that information is to be provided to him, Malad, my consent has to be taken. Without my consent, Malad, can that information be given is what I ask, Malad.
Yes.
So that is my first, Malad's proposition. And Rule 7, Malad,
Your argument is that your consent should be taken. If you don't give consent, then adverse inference.
absolutely, that is what Sterlite as
That-
well as
that we have
Malad,
noted, that
Make
we have
Money
noted.
says, Malad.
Yes.
Number 2, Malad,
Yes.
he says that the rules do not disclose, Malad, these specific things, Malad. Now, the whole basis of anti-dumping duty, Malad, is, Malad, my price, the injury margin, and all of this, Malad. And for this, what the law provides, that I should give a summary or a summary of the confidential information. So therefore, the designated authority in its wisdom, as far as this case is concerned, gave that summary to them, Malad. So, Malad, for my learned, and that is for the
What
DA
would
to
this,
decide.
what the summary would constitute of?
Malad, these summary, Malad, would constitute, Malad, whatever figures of that data can be given, because I don't know what has been given to him. Malad, so, Malad, maybe an average is given, the direct price is not given, Malad. So that information is given. It is done in every case, Malad.
Mr. Sharma,
Yes, Malad.
we just pose the question to you, whether it would be possible for the party to challenge the findings of the designated authority without having these figures available.
Malad, he is not deprived of the figures. All the figures, Malad, across the board, Malad, are given.
That is the only direction.
Malad,
That is the only direction.
Malad, that direction, Malad, but can that direction be passed, Malad, without asking me? That
If
is
it
my
is-
question, Malad.
If the nature of the information is not confidential, as the High Court has said, as the single bench has held,
Correct.
yes, definitely, you are not required to
So
be.
ask me.
Why? If it is not
But that is what
confidential,
the Supreme, Malad, may I-
question, your consent is relevant if that part of the information which is being provided is confidential, is considered to be confidential.
Yes.
Not the- So the High Court has recorded a satisfaction that this part of the information is not confidential, so no consent is required.
Correct.
Okay. Anything else to say?
Well, let's just 1 minute.
That's all, sir.
Malad,
Thank
there is
you.
the judgment, Malad, specifically says
Yeah,
so.
what do you know, sir? Thank you.
And Malad, may kindly see,
Yes.
Lordship will kindly see, Malad, that one decision, Malad, which says an intervener can file, Malad.
Yes.
And today, what I'm doing, Malad, today, all I'm seeking, Malad,
Yes.
is all these issues. Let it be, Malad. Let me come into the matter, Malad. That is all that I seek.
An intervention in his appeal.
Malad, I will show, Malad. Malad, give me 2 minutes, Malad. I'm so sorry, Malad. May I just hand over?
Yes.
Well, this is a company petition, Malot, but exactly a similar situation arose, Malot, where an intervener before the Bombay High Court filed an appeal before the Supreme Court. Malot, Lordships will see para 12. Malot, I'll read only the relevant portion, Malot, for paucity.
Yes.
Malot, we kindly see about 6-7 lines from the bottom. If the proceedings, Lordship sees that?
Yes.
Yes, of course. I'm so sorry. Give a copy. Give a copy. Give a copy. If the proceedings had continued in the company court, one of those persons could have benefited. The benefit was thus to accrue to one of the interveners was deprived of by the division bench by its present order. And in that situation, the appellants are persons who are aggrieved by the decision of the division bench and are entitled to challenge the said decision in this court. It is also to be submitted that the framing of a scheme so-and-so had overtones of a public interest and commercial interest. Now, my lords, the direction here, as far as this case is concerned, is broad-based. Well, if my learned friend says, well, and it is not treated as a precedent, because the matter is infructuous, I have no difficulty. But the problem is that if this becomes a precedent, my lords, then every party initiating a domestic investigation, my lord, will have to disclose confidential information.
Okay.
That is not what the law proposes, my lord. Thank you, Ramnanda. Well, and my learned friend submitted a decision. And that decision has been completely distinguished as in this particular case, my lord. I wanted to show that. Lordships will see para 10 onwards. In fact, from para 9. This was exactly the argument, Malak. This was the case of, as far as the society is concerned, where the society filed an intervention and thereafter wanted to file a petition in the Supreme Court. Mrs. Bakshi, learned counsel appearing for erstwhile managing committee, raises questions of locus of the appellants to prefer this appeal, relying on the decisions of the court in N. Swine versus B.K. Mohapatra. This is a judgment my learned friend cited. And Ravi Rao Gaikwad. Well, para 11, where the lordships distinguish that judgment. In Swine, this court was concerned with.
Will you read para 10, please?
I beg your pardon. Yes, madam.
Will you read
the interveners in this case were not permitted to intervene by the learned single judge, as was evident from the record, and they were
only, you missed the word not only.
They were not only permitted to intervene by the learned single judge in this particular case, also same, Malad.
Will you read the entire para, please?
Well, I'm so sorry.
That was a case wherein the interveners were allowed to act as parties.
But I'll read it again, Malad. The interveners in this case were not only permitted to intervene by the learned single judge, but it is also evident from the record that they were parties in the latest patent appeal also. I bow down, Malad. Let's kindly read up. In N. Swine, this court was concerned of a certificate in terms of Article 133 of the Constitution of India. And in that context, it was observed that the interveners had no statutory right to prefer such an appeal.
Read para 13, Mr. Sharma.
Yes,
this judgment is totally distinguishable.
Yes,
Seems that you didn't even bother to read it before citing
the
it.
appellants are members of the society and they've been pursuing the case before the High Court. They were impleaded as parties in the latent patent appeal.
So if they were impleaded, there is a right to filing an appeal.
Well, impleaded means they were interveners. That's how.
Mr. Sharma, please, not only interveners impleaded as parties.
Very well, Malad. I bow down then, Malad. My reading is slightly. Malad, what I say, Malad. Yes. And Lordships will then see right of the petitioners as far as an appeal is concerned. Your Lordship sees the next judgment.
Yes.
In the same paper book, Malad.
Yes.
Malad, para 29.
Yes.
Bottom of the page, Malad. Though they were not parties to the suit, last sentence of that page.
Reading on which page?
Page 42, Malad, top of that compilation that I handed, small, two judgment
Yes,
compilation,
yes.
page 42.
Hmm.
Though they were not parties to the suit, they could have filed an appeal with the leave of this court as an affected party.
Yes, sir.
What I'm saying here, that my rights are affected.
That you argued, you are now in rejoinder, sir.
Correct. And
So that you argued, we'll consider.
And Lordship has suggested that I become an intervener in their appeal. The difficulty is their appeal is only against the review order. They have not challenged, and what the review decides is only
The
2
review
points.
order, the original order merges in the order of review. Do we need to tell you that?
So I see that, but the points, that were urged as far as that, they do not become non-est completely, they remain, because that point was not even taken by them in the review. As far as whether a person.
Are you criticizing the judgment under review?
I cannot, it is, I am not concerned with that. All I'm concerned with,
Okay.
is that without asking me, and that,
That argument will take care,
Yes.
we will take note of that.
I'm so grateful.
Well, the next item has already been admitted. So that may question for hearing.
All right.
I have a small submission,
Yes.
and I wish to file an intervention also in that. This item, is infructuous. May I explain why? There's no need.
It has been admitted.
He's not intervener as yet. How?
Who are you right now in that?
At present, he's not-
I'm just assisting the court then,
No,
no.
don't worry. We have got our hands full.
Very well.
Yes.
That
Rate
may
appeal number 265 of 2022 में लिख दीजिएगा. The appeal has already been admitted. List for hearing in due course. What does the central government have to say in this
So they filed
application?
appeal, they have to withdraw it. They filed an appeal and they have withdrawn it.
No, in this application,
In
what
this-
is the stand of the central government? Is here.
No. We have already funded the copies.
In the IA, in his IA, what do you have to say? All right, central government supports. Okay, very well.
I'm highly obliged.
So we take note of the fact that the central government has supported the
Yes, that
respondent
will
in this
become
application.
quite a tremor actually, but very well. My learned friend has taken that stand.
Now you see, they at Guwahati have the advantage. Everything is there on YouTube.
Very well.
It can be replayed and
Absolutely.
confirmed.
Absolutely.
Very well.
Then let my learned friend's submission be recorded, then put
Ah,
up in the
yes.
order that they are
Yes, we'll
supporting
record
the
it, don't
stand, that the confidential information
Yes.
may be disclosed. Very well.
He's
Noted.
not saying the confidential information should be. Why?
Say that he has supported his arguments. That's
Correct.
what is.
Correct.
His argument is that your interlocutory application should not be accepted.
Very well. Very well. Grateful.
I'm-
All right.
Orders, item 7. Yes. All right.
May I please, your lordship?
Order reserved. IA order reserved. Yes.
May I please, your lordship? Pursuant to order dated 20/12/2022,
Yes.
passed by this honorable court, thereby directing the appellant to take steps for substituted service.
Right.
For newspaper, publication.
The
So that
step,
is- steps have been
the
taken.
applicants have published the notices issued to the unserved respondents
My lord.
have been published in the newspapers as per the office report. Thus, service in this interlocutory application is presumed to be complete on all the respondents.
My lord.
No one appears on their behalf.
My lord.
I'm appearing for respondent number 7.
This is Mr. S.S. Rahman, Triple S Rahman appears for the respondent number 7. However, the other respondents are not represented. IA is for condonation.
Yes, my lord.
What do you say to condonation?
My lord, I have stated, my lord, here what has happened, my lord.
I have no objection, my lord.
Mr. Rahman does not object to the prayer for condonation of delay of
My lord, 694 days.
694. What is the justification?
My lord, justification is that, my lord, there were earlier sets of councils, my lord, who represented the finance department. My lord, when this VW was taken on board, my lord, they defaulted and they did not inform the client. Later on, my lord, we came to
Client?
know.
The name of state is always reflected in the cause list.
My lord, here in this case, my lord, it was not reflected. We have specifically pleaded, my lord, in our, my lord.
Gentlemen,
application.
State versus so and so is always there in the cause list.
My lord, it is,
And state, can we believe that when the matters are called out in the court, the state council are not present? Whosoever is present has to take care.
my lord, that is absolutely
Then-
true. But here, my lord, the pleaded cases there, my lord, the names of the councils for the.
Names are not required to be mentioned.
My lord,
State through standing council.
my lord,
You just let us check the list now today. Check the cause list.
my
Are
lord.
the names reflected?
Yes, my lord,
GA Assam.
yes.
So name is not there.
No, my lord,
GA Assam was not mentioned even then.
my lord,
Where is the cause list in support of this argument?
my lord, we represent, my lord, the finance department.
Oh,
Yes.
all right. SC higher education, SC finance. Let us see the cause list.
My lord, that I will have to again produce. I will have to produce, my lord.
Yes,
It is
produce
not
the
a
cause
part
list
of-
in support of
It
it.
is not a part
This-
of the.
this
my
is-
lord,
This is a false aspersion, we will say.
my lord.
This is a totally patently false aspersion. That the names were not reflected. Name is only required to be reflected in the manner which is being done now. Standing council finance.
My
So
lord,
whosoever the standing council is, he or she is required to be present.
my lord, what has happened here? my
Yes.
lord, on the date when the names were reflected, on an earlier occasion, it was not reflected. Subsequently, when it was reflected, I have pleaded, my lord. Then, my lord, the earlier set of councils, they did not appear.
Where is the cause list? We don't have the practice of reflecting the names.
My lord,
It's only by the designation, standing council. In Guwahati High Court, there is no such practice.
Yes, my
That
lord.
the name of the government council is to be mentioned.
My lord is absolutely correct.
Then-
My lord, here, my lord, the pleaded case of the applicant as on date, my
So
lord.
now
is-
support your case by the cause list of the relevant date.
My lord, on that date, my lord, it was reflected, it was shown. But they
Let us
defaulted.
see the cause list. No. It is published. Where is the cause list? Let us see that.
My lord, then, my lord, I will have to. procure the
Yes.
cause. My lord, it pertains to the, my lord, year 2016.
We are not bothered.
My lord,
But this is a false plea, we will say. Blatantly false plea.
No, my lord. Lordship will kindly, my lord, for a moment, my lord.
We are putting you the question third time.
My lord,
Is it a practice in this court to publish the names of government councils in the cause list? Or was it there earlier?
yes, my lord. My lord, so far as the department.
Mr. Chaudhary, President Bar, Senior Advocate Ms. Chaudhary,
My lord,
they all say no. This was never the practice. Only SC. So once SC is shown, whosoever is the SC standing council, he or she has to appear.
Yes, my lord, here the pleaded case is, my lord, it was shown they defaulted. They defaulted,
Let us see the cause list.
my lord, then lordship will kindly grant me some time.
On council, the case as set up in the interlocutory application
My lord,
seeking condonation of delay is that names of the concerned government council representing the appellant department, Department of Finance, were not reflected in the cause list, and hence, the case could not be attended and was dismissed for want of prosecution. However, we are not prima facie satisfied with the said submission
no,
because
that is not my plea, my lord. My
then,
lord, on that particular day of dismissal, it was reflected.
then
On an earlier occasion, it was not reflected. My lord, notwithstanding that, my lord, it was listed on 29/9/2016.
yes.
That is the pleaded case out here.
Hmm.
On 29/9/2016, the councils representing the finance department
Hmm.
defaulted and they did not appear. On 29/9/2016, they defaulted.
That's what
and-
we are saying, Mr. Puzari.
My lord,
the names are never reflected in the cause list. It is only designation standing counsel submits that though the names of the concerned standing counsel were reflected in the cause list, but they did not attend
My lord,
the court.
my lord.
However, we are not satisfied with the such submission because we have seen from the cause lists of Guwahati High Court that there is no practice to mention the name of the government counsel in the array of counsels as displayed in the cause list. Hence, Mr. Borupuzari is directed to place on record the cause list of the date on which the writ appeal was dismissed for want of prosecution.
29/9/2016.
Yes.
Lordship may kindly record it.
29/9/2016.
My lord. Lordship will kindly grant me 2 weeks time, my lord.
2 weeks time is granted for doing that.
I'm so grateful, my lord.
Item number 8.
May it please your honor. May it please your lordship.
Yes,
As per the direction of this court, order dated 21/12/2021, we have been directed to include Assam Rajiv Gandhi University of
interlocutory
Cooperative
application
Management.
filed by the on behalf of the appellant seeking impleadment of Assam
Rajiv Gandhi University of
Rajiv
Cooperative
Gandhi
Management.
University of so and so is accepted. Amended cause title be filed. Will be furnished within 7 days. Amended cause title in the writ appeal be furnished within 7 days. List thereafter.
Obliged lordship.
Item number 9.
Here, your lordship, IA has come for condonation of delay of 82 days. Your lordship,
82 days.
in
Yes.
preparing the appeal, your lordship.
Who is there? Standing Council Finance, Higher Education. Yes. What do you say?
But regarding delay, I have no question, my lord.
IA number so and so has been filed by the applicant writ appellant seeking condonation of delay of 81 days occasion in filing of the connected writ appeal. First of the respondents counsel do not object to the prayer for condonation. Otherwise also come up, having gone through the grounds as set out in the application seeking condonation, we find that the reasons assigned therein are germane and germane. Hence, the application is accepted, delay is condoned, the official registered the connected writ appeal and list the same for admission.
Yes. Public.
Item number 10.
There is one more matter which is not being listed. Let it be, your lordship will hear this matter. Same will follow in that
Sikkim,
case.
there are few more appeals arising out of the orders of Sikkim High Court. Similar appeals, wherein the university has not been allowed to conduct examinations beyond Sikkim.
When this is matter, isn't it?
जाके चेक करिए उस सिक्किम वाला का मैटर लग रहा है. So perhaps we should hear that together. Who is appearing? I don't recollect.
And one more matter is, I'll give the number.
All right, you give the number. The similar controversy is
138.
involved in writ appeal number so and so,
138 of
and
2000.
वो सिक्किम वाला भी निकाल दीजिएगा. That has been transferred under directions of Honorable
This is
Supreme
Honorable
Court.
Supreme Court.
Yes. You appear. Wherein we gave permission for one visually impaired person, the examination to be
I
conducted.
think that's a different. I appear in the matter regarding status of this.
No. That appeal is regarding non-permissibility of the action of the university in holding examinations beyond the state. So that we had granted permission to one visually impaired person that his examination shall be held at Pune. We'll find out
It will come after vacation or before vacation?
after vacation.
After vacation. Two matters. Next matters, This matter is not being listed 138 of 2023.
138 along with search. You have some urgency, then we can take it up.
No, it's okay, my lord. I think your lordship is
Or we
hearing
can
that-
issue notice if you want.
Yes, notice may be issued.
Issue notice to the respondents.
Yeah.
You are appearing? Who is appearing?
For 1, 2, and 4.
Okay.
What is the IA about?
Stay of the judgment. Stay of the impugn order. Stay of the impugn order.
That's a tough call. Yes. Issue notice to the respondents. The response numbers 1, 2, 1 and 2 are represented by learned counsel. 1, 2 and 4 are represented by learned counsel, Mr. So and so. The steps for service on the response numbers 3 and 3. For 3, madam, का लिख दीजिएगा. Steps for service on the respondents, remaining respondents, be taken within 7 days, whereafter process we should connect with so and so number लिख दीजिएगा. Notice we issued on the IA for interim relief as well.
Item number 11.
Meet the lordships. My lord, the appellant before lordship was a respondent in the writ petition, and the writ petition was filed challenging minus of the selection committee of 2007 that was filed in my lord 2019. That is for the promotion of from LDA to UDA, and then my lord determination of seniority.
You were born in cadre 3 years after the respondent.
My lord, the question here is the vacancy against which I have been promoted, that is of 2001, and the writ petitioner was promoted against the vacancy of 2006.
The seniority in the parent cadre, the feeder cadre, doesn't get wiped off because the particular post for promotion became available at a particular point of time.
My lord, in fact, my lord, my submission would be contrary to that, my lord. Because the rules require, procedure require that every year promotion has to be made.
Yes, that's
in 2001, that was not done. It was done in 2007, my lord, after the 2 more vacancies arose. In 2001, the vacancy for the reserve category STP arose. And then, my lord, there was a backlog, and that backlog was carried out. Then, my lord, against that vacancy, I was appointed. I was selected. And,
what is your date of selection? Can the seniority relate back to the year of creation of vacancy?
My lord, the
date of creation of vacancy.
Yes, my lord.
What is your actual date of promotion?
What actual date of promotion is
same as the private respondent.
Yes, my lord. But then, since my lord, my vacancy arose in earlier point of time, and the rules, because my lord, in this
vacancy may have arisen earlier. The exercise didn't take place then. Actual promotion is effective from 23rd February 2007.
True, my lord.
Which is the same as the private respondent.
Yes,
who was born in cadre 3 years prior to you.
But then, my lord, the vacancies for each year has to be, my lord, considered separately. So, my lord, my vacancy.
Then you should have come to the court in 2001 saying that please calculate the vacancies. Vacancy in my category is now falling in this very year. So I'm required to be promoted immediately.
That was I was not aggrieved, my lord. I was not aggrieved, and my lord, the writ petitioner also, my lord, did not challenge it till, my lord, the next higher vacancy. My lord,
does your promotion order read that you will be treated to be promoted?
No, my lord.
Then
no, but then, my lord, the rules, my lord, the relevant rules have not been considered because, my lord, the honorable single judge has said that there cannot be any promotion against roster point in a seven post cadre. That is the finding. But the, my lord, rules say, my lord, if I may draw your lordship attention to the rules, my lord.
Mr. Chaudhary, assuming that view is not correct, was it your case at any point of time that your promotion should be deemed to be taken place on the date the vacancy
arose? No, we are on the point of seniority, my lord. I, having been, my lord, selected against a post which occurred in earlier point of time, it is not in my my lord, domain to get the promotion earlier. But then, my lord, when the selection committee sat, it has to, my lord, consider the vacancies year-wise. And the finding, my lord, of the honorable single judge, that, my lord, relying on 2 decisions of the honorable Supreme Court,
Yes.
those are, my lord, relating to the initial appointment, not regarding promotion. And the, my lord, promotion is guided by the rules
Yes.
and framed under the act. And the, my lord, rules specifically say, my lord, if I draw your lordship attention to, my lord, Rule 5 of the Assam Person Silted Reservation Rules 1983, your lordship may.
All right. Yeah. Admit issue notice will not grant any stays, sorry.
That will create
Absolutely no. Then you take a decision right now. Carry it to the Supreme Court if you so want.
notice be issued.
No ground is made out to
Right.
pass any interim order. Thus, the prayer for interim relief is refused.
Can I pay for early hearing in that event?
You see, just first get the affected parties served. Step for service be taken in 7 days, whereafter process be issued.
All right.
Item number 12.
इसमें खांजी interim की 2 लाइन लिखाएंगे अंदर.
May I please lordship, my lord?
Yes,
There is an order, my lord, in tomorrow's position, item number 15, my lord.
there is
That, my lord, this matter was to be heard along with that matter. There was an order on 17.
there is one more matter.
Yes, my lord. Tomorrow, item number 15, my lord, listed.
Tomorrow,
Yes, my lord.
list, you want this to be taken up tomorrow?
Item number 15 with item number 15, 1-5.
List tomorrow.
With item number 1-5. Item number.
It will be listed tomorrow. You
Okay.
make a mention when
Okay.
15 is taken up.
Obliging.
Item number 13.
Show it to Mr. Das. Mr. Das, this is the matter. Sikkim.
I'll just photostat one copy.
You retain it, no issues.
Repeat.
May it please your lordship. Your lordships, in this matter, respondent number 7, who is a private respondent, and the Central Pollution Control Board.
Little louder, madam.
May it please your lordship. Your lordships, in this matter, the private respondent number 7 and the CPCB, who is the respondent number 3, has filed their affidavit in opposition. Your lordship, 10 days time may be given to me to file the rejoinder in this matter.
Then counsel for the petitioner. Praise for it is granted. 4 weeks time. 4 weeks time. So as to file an affidavit to counter the affidavit filed on behalf of respondent number 7.
And 3, your lordship.
School की boundary पे list up 4 weeks.
Item number 14.
May I please the lordship?
We could file the affidavit on yesterday.
Okay.
Bringing the postmortem report.
PMR you have
Yes,
filed.
yes, we have filed.
Which time for file, sir, replay in this regard?
Second.
We filed it yesterday, possibly. The reportation component.
We don't want to comment on what is happening. We're going through this petition. Mr. Nath submits that he has filed the
Additional affidavit bringing the postmortem.
postmortem reports through an affidavit as directed by this court on 15/5/2023. The affidavit and the documents we brought on call. The counsel representing the petitioners. Praise for it is granted. How much time do you need? 2 weeks time to file. Counter thereto, if so required. List after 2 weeks.
Item number 15.
Lordship.
Yes.
Lordship, in item number 15, Lordship, will be filing affidavit on behalf of the Chief Secretary, Lordship. So in this matter, Lordship, we require 6 weeks time, Lordship.
We already given you sufficient time.
2 weeks was given.
The time was granted on 19th January.
No, Lordship, thereafter we filed on behalf of the Hill Areas Development Department, Lordship. But on the last
Respondent number
occasion,
one,
Respondent number one.
the direction was given on respondent number one.
yes, Lordship, but the Hill Areas Department, and that's why we want to file again the affidavit, Lordship. That's why we're seeking some.
Additional Senior Counsel, MS M. Bhattacharjee, praise for and is granted further opportunity of 6 weeks so as to file an affidavit on behalf of respondent number one.
Deeply out.
Okay.
Item number 17.
Padmini Singha se covered. Yes. The case is covered by Supreme Court judgment in the case of Padmini Singha.
Your Lordship, I'd like to state that there is a subtle difference in the
Mm.
matter of Padmini Singha and why the time period of 3 days is important in this matter. If your Lordship takes up the matter of Padmini Singha, I have extra copies, Your Lordship.
Yes. Now, what is the position? Who is holding now? Who is the president now?
The Vice President is running the office, Your Lordship. The
Vice
Vice President is
President.
running. If your Lordship can kindly come to
Yes.
page 563, which is paragraph number 3, Your Lordship.
Yes.
This shows, Your Lordship, that the respondent therein had lost the presidentship by a margin of 9:1 votes.
Mm.
In this matter, Your Lordship,
Mm.
if your Lordship comes to the order itself and the pleadings in the writ petition,
Mm.
the margin of the votes cast was 7:3.
That doesn't make a difference. It's a majority of persons voting.
In fact, Your Lordship, in no confidence motion, there is nothing substantively that I argued before this court. The only matter where I can submit before this court
Technicalities.
is on the procedural part of it.
Procedural.
In fact, if your Lordship will kindly come to page 169 for a moment. 169, Your Lordship.
Reading from the judgment,
I'm from judgment, Your Lordship.
para,
169.
para.
Yes, Your Lordship, paragraph number 7.
Yes.
If I may permit to read, Your Lordship.
Yes, yes.
Mr. So-and-so and Mr. So-and-so have adopted the submissions made on behalf of the state respondents. Mr. So-and-so has submitted that requisition dated 19/1/2021 was duly served upon the petitioner. When the petitioner failed to convene the special meeting within 15 days time period, the secretary of the Gao Panchayat of the respondent number 8 had intimated the matter to the president of the Anchalik Panchayat.
Mm.
In this regard, Your Lordship, if Your Lordship can kindly take up the Panchayat Act, Your Lordship, for a moment.
Yes. Assam Panchayat.
Assam Panchayat Act, Your Lordship, section 15.
Mm.
Section 15.
Mm.
Your Lordship states in the second paragraph that such a meeting shall be specially convened by the secretary of the Gao Panchayat with the approval of the president of the Gao Panchayat. Now, if Your Lordship comes to page 154,
Mm.
154 is the affidavit which has been filed by respondent number 7, which talks about the fact that the first requisition was occasioned on 19/1/2021. Your Lordship can see that? Seen that?
Mm. Mm.
If Your Lordship now kindly come to page 46, the requisition which is 19/1, page 46 of the appeal, Your Lordship.
Yes.
This was a requisition which was sent to the secretary by the ward members who were disgruntled. This does not qualify under section 15 clause 1 as the first instance of requisition. Your Lordship will come to the second, so subsequent annexure of the writ petition, which is at page 55. Page 53, in fact, Your Lordship. Page 53. Which is the appellant here. With due respect, inform your last that on 19/1/2021, some of the members of the Panchayat have submitted written letter before the Panchayat office expressing no confidence against you. Although you have been asked to convene a meeting on 19/1/2021 and on 27/1/2021 on the aforesaid subject matter, you have been found not giving any importance in this regard. Therefore, is informed to you in written to give time to convene a meeting to the Panchayat office in respect of the said no confidence motion. Now, assuming the 19/1 was served on the petitioner, that does not qualify the requisition of first instance under the Act.
what should be construed as the first instance of moving a no confidence motion against the appellant happened on 27/1/2021. Thereafter, if your lordship, I'll take your lordship's attention to page 172 for a moment again, the judgment.
Yes.
172. Your lordship would see in paragraph number 12
Yes.
that there is no dispute to the fact that on 19/1/2021, 7 ward members of the Gao Panchayat had submitted a requisition in writing before the secretary of the Gao Panchayat.
Just hold on.
Yes.
What is your argument regarding this first requisition of 19th January?
19th
Why it
January,
is bad?
assuming it's not bad, it does not qualify as a requisition under section.
Why
15.
not? Why not?
Because your lordship, section 15 talks
Yes.
about such a meeting shall be specifically convened by
The secretary.
Yes.
With the approval, yes.
With the
So it is addressed to the secretary.
The approval was sought from the president on 27/1/2021.
So,
The first instance of seeking an approval happened only on
Yes.
27/1.
yes.
Thereafter, 15 days should have lapsed before the president of the Anchali Panchayat should have taken any steps. Now, this honorable single judge had failed. to take-
Let's see.
Yes.
You say that this was not served on you.
Assuming it was even served on me, your
On
lordship.
what date?
Assuming it was served on me,
Then-
assuming it was served on me on 19th, that does not qualify as a first requisition under section 15. The first requisition under section 15 has to be occasioned by the secretary seeking to convene a no confidence motion with the approval of the president. If your lordship sees that the requisition dated 19/1, it does not seek the approval of the president, nor does it seek to hold a no confidence motion. It was addressed to the secretary by the ward members.
But what is the prayer?
The prayer is to set aside the
Ground of no confidence only.
yes,
So that is what else are they supposed to write?
the time.
Their desire
Yes.
to convene a meeting for considering the motion of no confidence.
The entire process started on 27th, thereafter, not 19th, your lordship, because under 19th, under the section, it is the secretary who is to occasion that letter. The letter for the first time in this instant issue was occasioned on 27/1/2021.
Where do you read that?
Your lordship, that is at page 46. At page 53, I apologize, your lordship, page 53. Page 53.
Yes.
Page 53 is the first instance of when the requisition was occasioned by the secretary.
So this he comes out in writing.
Yes.
He says that you have been orally requested on 19th, but you have not given any credence to that request. That is what it is mentioned.
That is what is the
So
understanding of
it
the secretary.
doesn't say,
Yes.
the section doesn't say
Yes.
that the secretary then shall issue a letter in writing to the president. He has
does not-
intimated it to
It
president.
does not say that. It does not say that. What the act says is that the secretary has to convene a meeting.
So
Now the
convene a meeting by requesting to the president.
with the approval of the president.
So that he has requested,
Yes.
that is what the letter says.
That is what he has said. That is what is his understanding of the act, subject to your lordship's interference in the matter. In fact, when the secretary has to convene a meeting, the initiation of the process has to start from the secretary himself. It is the ward members who have brought the information to the notice of the secretary. that
Initiation
we are disgranting-
shall be through the president. Secretary in his own capacity can't do it.
The
He has to
approval-
request the president.
Subject to my limited understanding, it is the approval of the president. The initiation of the process has to be from the secretary.
He requests the president.
Yes.
This is the application which has been received
Yes.
on 19th.
Yes.
Kindly approve the meeting.
Yes.
You don't do anything, then what he does?
That ideally, your lordship's understanding is very correct in this matter. In fact, this honorable court's, the single judge's order is absolutely silent on the fact that whether I received it on 19th or 27th, that issue has not been gone into. Thereafter,
What is your answer to this date mentioned in the letter at page 53? What is your plea regarding that? Let's see.
page 53, your lordship.
Yes.
Yes.
You don't dispute that you have received this.
No, that issue, in fact, it is on submission in the writ petition, in the pleadings, your lordship, that I did not receive that on 19th. That is my submission in the writ petition. And that issue has
Gentlemen,
not been.
Gentlemen,
Yes.
come to page 53.
Yes, your lordship.
Yes. What is your response to this letter which you received admittedly on 27th?
I received the letter on 27th.
Now, what is your response to this?
Thereafter, your lordship, thereafter, if.
Did
the
you at
president-
any point of time mention to the secretary that this date 19th you have mentioned
Yes.
in this letter
Yes.
is incorrect? You never told me this fact.
That was raised by me subsequently after the results were declared. In fact, that is an omission in my part that I cannot
That
dispute.
is an
That's a part of
omission
my-
which goes to the root of the matter. It is to be presumed that this letter was conveyed to you intimation was given to
Your
you.
lordship would see the time is the only factor I have in a no confidence motion. I can be the best of administrators and still I can be taken off by.
That's the,
and
that's the
time is-
democratic process.
And time is the only security
Yes.
that I have. Your lordship would say, Padmini Singha, the matter was already decided by the voting faction against the member. Here, I just needed one individual to be on my side, just one individual to be on my side.
But you didn't get the time to sway one individual in
They
your.
were already swayed. They already swayed because they voted for me. In fact, I was voted directly by the population of the Gao Panchayat.
Right.
The ward members are directly elected by the members, and so am I.
Hmm.
In fact, I'm directly elected, so I should have been given that opportunity of 3 clear days to fight my case.
Hmm.
Otherwise, I don't have a case before this honorable court. I cannot fight the matter on substantive issues. It's only the procedural lapses that I have that I can point out.
Procedural lapse is not there, sir. Your omission part, you don't dispute that you never contested this fact, which was mentioned in the letter, that intimation was given to you on 19th itself.
I did not contest that fact at that point in time. In fact, my applications were issued at a later point in time in the month of June and July in 2021. It is only when the impugned order came that I had to vacate my office. Now, timeline is the only factor that I had. In fact, even the 3 clear days notice, that period, if I'm leaving that aside, the lordship would see 15.1, it talks about the first instance by the secretary. And thereafter, after 15 days,
yes,
page 19 of the Assam Panchayat, Your Lordship.
Yes.
Such a meeting shall be presided over by the president if the motion is against the vice president, and by the vice president if the motion is against the president. Now, Your Lordship would see if the motion was against me as a president, it was imperative that the vice president be according to approval.
The vice president would have presided had the meeting been convened.
Yes.
The meeting was not convened, so information was sent to the Anchalik Panchayat.
The Anchalik. Now, Your Lordship would see, again, which I'm substantiating on my point that 27.1 was the first issue that had happened in this matter. 15 days had to pass. 15 days had to pass in this matter.
So this 27th actually is a reminder. Time is running out, please convene the meeting. That's a reminder to you.
That as well be. In fact, there's another judgment of the Honorable Court, which I had already supplied a copy for Your Lordship. 2021 writ appeal. That goes squarely against Padmini Singha, Your Lordship.
Padmini Singha, if the judgment is against Padmini Singha,
yes,
it has to be treated as per income.
Yes, I'll not be relying on that. In fact, I've provided a copy for Your Lordship on the earlier occasion.
Yes.
Your Lordship, so far as the giving 3 clear days is concerned, Your Lordship, he has received the notice on 16/2 and the meeting was held on 19/2 and he was present. He participated, Your Lordship.
Okay.
So this is the afterthought, Your Lordship.
Dismissed. Got the notices.
Item 18.
We did not change the meeting termine for the subsequent. Yes.
This appeal against the judgment of the Honorable Single Judge, my lord, where the challenge was with regard to a clause in the NIT, my lord, which favored the highest bidder to submit its documents after the opening of this bid document. Now, there are 2 conflicting judgments of this Honorable Single Judge, my lord, in this issue, my lord. First, Your Lordship, may I take Your Lordship to the first judgment? Judgment starts from page 38, my lord.
2 conflicting judgments in this very matter.
Yes, my lord, there is a clause. I'll refer to the clause first, my lord. Page 95 is the NIT, my lord. The offending clause is clause 11 at page 98. May I read it? The bid offered by the highest bidder for the settlement of all Hat Bazaar fisheries parkings will be accepted for consideration. And if it is found that the bidder of the highest bidder had not submitted the necessary documents, except the court fee and the earnest money, then the said bidder will be given 3 days time for submission of the same. And if he or she fails to submit the necessary documents within the said stipulated 3 days, his quotation will be rejected and his earnest money will be forfeited, and the quotation of the bidders of the second highest bidder will be considered for settlement subject to the some terms and conditions. Now, if the lordship turns to page 100, Miller, well, what are the necessary documents which has to be submitted? Clause 14 to clause 17 mentions about the documents. Now, clause 18 at 101, Miller, it says that if the documents from clause 1 to 17 of the part 1 and part 2 are not fulfilled, then the tender application will be rejected. This NIT in clause 11 gives a benefit to the highest bidder for giving the documents after the bid is. This similar NIT, Miller, this is an NIT of the Panchayat department, Miller, and similar NITs, the model of this NIT is being followed throughout the state. Now, in a case which was where the issue was raised before the Honorable Single Judge in WPC number 6902 of 2021, page 38. Pallav will find page 43, the issue raised before the
43.
Page 43, 6.1, para 6.1.
Yes.
Pallav. By referring to clause 10 of the tender notice, he has contended that the petitioner, being the highest bidder, was entitled to be given an opportunity to submit the requisite documents in case the tendering authority has found the bid of the petitioner deficient of some document within a period of 3 days. As clause 10 has incorporated the provision of forfeiture of the earnest money in the event of default to submit the documents to be asked for within a period of 3 days, the same was required to be followed by the tendering authority. But in the case in hand, the tendering authority did not adhere to the said clause. It is his contention that the tendering authority has to abide by the terms and conditions of the tender notice, and it could not have deviated for the same. Now, the objection raised in respect of this argument is at page 44, para 8. Mr. Samas, so-and-so learned counsel for the respondent has relied upon the decision of this court in Jalaluddin versus so-and-so reported in so-and-so, wherein reference of another decision of this so-and-so of this court is made. He has submitted that the highest bidder means the highest valid bidder and not one who has offered the highest bid value. With regard to the responsiveness of the bid of the petitioner, vis-a-vis the respond number 8, Mr. Sama has submitted that the General Standing Committee of the Jilla Parishad in its resolution had clearly found that the bid of the petitioner was non-compliant one, whereas the bid of the respondent was compliant one. It is further contended that in a bidding process, the price cannot be sole criteria for settlement of a market, but it is the responsiveness of the bid which has to be given precedent. As regard clause 10 of the tender notice, so-and-so has submitted that if the said clause is made applicable in a competitive bidding process, the sanctity of the competitive bidding process, which requires fairness, transparency, definitiveness, and non-discriminatory level playing ground for all the bidders would stand removed. In exercise to be undertaken in the nature mentioned in clause 10 of the tender notice, the same would result in a treatment of unequals as equals with a direction impact on the equality clause enshrined by Article 14 of the Constitution of India. The tender notice has incorporated the terms and condition to be fulfilled by the participating bidder, more particularly clause 11 to clause 16, which requires the bidder to submit number of documents at the time of submission of the bid, and clause 17 had in clear terms laid down that in the event of non-fulfillment of terms and condition incorporated in the tender notice, the bid of such bidder would entail rejection. Insofar as clause 10 of the tender notice is concerned, the interpretation of such petitioner has adopted to predatory pricing, which is easily evident from a comparison with the annual value fixed by the government for the market rate of rupees so-and-so. The discretion is available to the tendering authority to accept a reasonable bid, which may not be the highest bid in terms of the price. In support of his submission, he has referred to the Honorable Supreme Court of India in Jagdish Mandal so-and-so. Now, the finding of the Honorable Single Judge starts from page 53, Miller, to this issue, para 21. From the above, it is certain that
before that, come to para 18.
Miller, para 18.
51. Yes.
On perusal of the notification dated so-and-so of the Panchayat and Rural Development, Government of Assam, it is found that the same was issued to all its chief executive officers. It was stated herein that in order to ensure the settlement of the market cards fisheries to the highest bidder for enhancing the collection of own source of revenue of Panchayat, the chief executive officer were requested not to cancel any bid of the highest bidder on account of non-submission of the required document as per tender notice except court fee and earnest money, and to allow such highest bidder to furnish the documents before offering the settlement. On close perusal, it is noticed that the said notification pertained to the settlement process of market cards fisheries at the levels of Jilla Parishad, Anchalik Panchayat and Gaon Panchayat respectively for the financial year 2018-19. This petitioner has not brought on record any other notification of the state government whereby the state directives has also been extended for the subsequent panchayat financial years, including the panchayat financial year 2021 and 2022 with which the present list is concerned. On the other hand, the letter bearing number so and so 23/4/2021, the government in panchayat and rural development was in respect of the process required to be followed for settlement of the market fisheries and ghats under various PRI institutions during the Panchayat financial year 21-22. The contents of the letter dated 23/4/2021 is found silent on the aspect of providing time period to the highest bidder for non-submission of the required documents and of granting opportunities to such highest bidder to submit the documents which were not submitted with the bid. Though the said letter dated had mentioned about a model notice inviting tender for Panchayat financial year 2021, a copy of the said model notice inviting tender has not been placed before this court by any of the parties bidder designated. The bidders participating in the competitive bidding process have no other alternative, no other right except the right to equality and fair treatment in the matter of evaluation of the competitive bid offered by them in response to the concerned notice inviting tender in a transparent and non-discriminatory manner and free from hidden agenda. At the same time, the procedure to be adopted in a competitive bidding process by the state or any of its agencies, instrumentalities, which is for the distribution of the state largesse in one form or other, must have to be fair, transparent, rational, providing equal opportunity to all interested and eligible persons to the parties to participate in the process. The decision of the tendering authority in the matter of evaluation of a bid or in awarding of contract must not be arbitrary, irrational, and unreasonable. If the matter of evaluation of bid or in awarding a contract has to conform to any statutory prescription, then the tendering authority must be alive to such statutory prescription while evaluating the bids or while awarding a contract which is in the nature of distribution of state liability. The decision-making process of the state or any agency instrumentality of the state in evaluating the bids or in awarding contract is required to keep the possibility of discrimination, arbitrariness, and favoritism out of the purview, and the same should be transparent, fair, bona fide, and public interest. The power of judicial review in respect of the matter relating to the award of tender is for the purpose of checking arbitrariness, irrationality, unreasonableness, and bias. It is intended to check whether the choice or decision is made lawfully and not to check whether the choice or decision is sound. Though in the matter of awarding contract by the state or any of its agencies, price is one of the relevant criteria, but price is not the sole and decisive criteria. The maintenance of sanctity of a competitive bidding process on the aspect of fairness, transparency, and definitiveness provide an equal level playing field cannot be compromised with the acceptance of a bid which is otherwise not valid, being non-compliant to terms and condition of the tender notice.
The other judgment you referred to, that was not placed before learned single bench?
Malad, this judgment was not placed before.
May I please, Your Lordship? Here, Your Lordship, there are specific cases that the impugned judgment is in conflict with the judgment passed by coordinate parents, Your Lordship.
Yes.
Your Lordship, in the two writ petitions, Your Lordship, this is different, Your Lordship. In the earlier, the learned single judge order, there, Your Lordship, the writ petitioners were praying for benefit under clause 10. In the subsequent case, Your Lordship, they were challenging the clause 10.
Yes, that is what his argument is. Clause 10 has been virtually declared in ultra virus by the single bench. The clause 10 has
Your
not
Lordship,
been approved.
Since Your Lordship, the lease is different, Your Lordship, because the petitioners were asking for benefit under clause 10, Your Lordship. The observation made by the learned coordinate bench, Your Lordship, in the nature of obiter dicta. So it has no binding authority upon the other coordinate bench, Your Lordship, because this is different.
Which judgment you say is obiter dicta? The earlier one which is cited earlier, or
Is the earlier one.
why the specific condition has been considered? Challenge was given to the condition. It was examined.
Your Lordship, in that writ petition, Your Lordship, they kindly see the page number 43 of the appeal, Your Lordship.
Yes.
Clause 6.1, the judgment, Your Lordship, or earlier judgment.
Para 6.1.
6.1.
Yes.
Here, Your Lordship, kindly see what's the dispute. He has contended by referring to clause 10 of the tender notice, he has contended that the petitioner, being the first highest bidder, was entitled to be given an opportunity to submit the requisite documents in case the tendering authority had found the bid of the petitioner deficient of sub documents. So here, Your Lordship, he is asking for benefit under clause 10, Your Lordship. In the The subsequent judgment, they impugned here, your lordship.
Hmm.
Here, your lordship, the petitioners were challenging the clause 10 itself, your lordship.
Hmm.
They have taken part in the bidding process, your lordship, and the present appellant, your lordship, he stands as sixth highest bidder, your lordship.
Okay.
And he has not met the other five bidders, not party here, your lordship.
Okay. So the higher bidders have not been made party.
Not
What do you
met
say,
the
sir?
party.
But to my instruction, Miller,
Hmm.
this appellant has not participated in the tender process.
Then
This
he
is
otherwise
also
also
the repetition.
He has participated in.
he has participated.
Participated. That is the, your lordship, the comparative.
And your writ
statement.
appeal will fail on this ground only.
But in this, Miller, the
Having participated and lost, if you file a writ appeal without impleading the successful bidders or the higher person, the bidders who stood higher to you on the basis of their financial bids, then your appeal has to fail.
if
You
your
are
lordship
in
finds-
appeal on
Serial
behalf of
number 6, your lordship. In the
Mahmood
comparative-
Hussain. Mahmood Hussain,
Mahmood Hussain, your lordship.
number 6.
In the another, there is another appellant also, your lordship, in the subsequent page, your lordship.
Yes.
His name also appeared in the sixth,
Who is he?
Abdul Karim.
Abdul Karim.
Abdul Karim. They have submitted their bids, your lordship, for two different markets, and they stood sixth in respective markets, your lordship.
Abdul Karim is not there. Abdul Qasim is there.
Your lordship.
Who is the appellant number 2? In an event, even if one of the appellants is there and he has participated, then without impleading the
Abdul Karim. your lordship.
Abdul Karim, second appellant.
Abdul Karim is not there in your list. Let's check, let's check. Abdul Karim.
In the comparative statement, your lordship.
Is for which market? Bichmari.
He was submitted his bidding for Beshimari daily vegetable market.
Hmm. Abdul Karim, yes, he is there. He is there. Imran Hussain. No, that's not the man. This guy is son of Azazuddin Ahmed.
They were not part. Both are 60 rank in two different markets here.
Hmm? Name of guarantor hai. Acha, theek hai. Yes, both of you participated, not impleaded. All right, heard.
But may I take instruction on that because we were the settlement holder of the earlier bid, Miller. Because
That
in
is of
this bid,
21, 22,
21,
this is
22.
22, 23, your lordship. And now the fact is that on 30th of this month, your lordship, this tenure is going to be complete, your lordship.
yes,
Only
as on
20 or
today,
25 days.
as
is
on
left.
today, there has not been any settlement in.
Doesn't matter, but you have come to the court without impleading the higher bidders
Malad,
whose
your
bids are bound to be considered
Malad.
better at a better footing
Malad,
than
the
your bids.
Malad, the challenge in the repetition,
Yes.
Malad, and the prayer which we have sought in the page 92 is with regard to the validity of clause 10.
Lost and all right, understood.
Malad.
But thereafter the process has been completed. You participated. Without challenging that condition, you participated. And you stood lower. Now you say, without impleading the persons who have made a higher bids, offered a higher bids without impleading. Necessary party is not impleaded.
Malad, can it be on Tuesday, Malad? Let me have an instruction on that, Malad, because
Your
my
lordship.
instruction in the repetition, Malad, was that
Learned counsel for the respondents has drawn the court's attention to the document verification report for settlement of the markets in question, market of league markets in question, which indicates that both the appellants participated therein and stood much lower in the financial bid evaluation. It is further submitted that persons whose bids were valued higher have not been impleaded as parties in this writ appeal. Faced with this situation, Learned counsel for the appellants faced for short opportunity to complete his instructions list on Friday. Tomorrow. Yes.
Obliged.
Item number 19.
Well, Lordship, I am required to file affidavit here. I have already given my colleague to just get it filed. Not kindly take up next week. Lord.
At 2.
At 2, by that time I'll file the affidavit. I'll give.
What is the writ appeal about?
Well, writ appeal about.
Well, in the writ appeal, my lord, the appellant was given a contract, road construction contract. my lord. That contract was terminated and the work was given to another person. I'm challenging both, my lord, because both are interconnected. Now, in the name of giving the work to the, my lord, the private respondent, they have committed all illegalities, my lord. Their own internal inquiry report revealed that. And my lord, the contract was terminated by executive engineer, but under the terms of the contract, it is the chief engineer.
Employer is the chief engineer, that was it.
And no notice, nothing, my lord.
Password.
Let the matter be taken on next week.
And it's not submit that he would be filing he has filed.
No, I have already.
He is in the process of filing the affidavit on behalf of the respondents. Number so and so.
Next Friday, my lord.
The affidavit upon being filed be brought on record. List on 16th.
My lord. Deep level.
For respondent number 2, I am filing.
Respondent number 2. Supplementary eligible.
Supplementary list, item 36 and 37.
May it please your lords.
Yes.
And the matter relates to appointment of member of Arunachal Pradesh Public Service Commission. Now, what had happened, my lord, after our appointment, before we could take oath, my lord, our appointments have been recalled, and my lord, a fresh advertisement has been issued. Now, we filed a writ petition before the learned single judge, my lord. The learned single judge did not pass any interim order. We are aggrieved by refusal of the interim order, that is, we are before your lordships.
Okay.
Now, what had happened, if your lordships will kindly come to page number 69, my lord, of the second appeal. I mean,
Item 37.
okay, item 37, my lord. Page 69. In exercise of the power conferred under clause 1 of article 316 of the Constitution of India, read with clause 4 of the Arunachal Pradesh Public Service Commission Regulation 1988, Governor of Arunachal Pradesh is pleased to appoint MS Rosie Taba as member Arunachal Pradesh Public Service Commission.
Reading at page number?
Page number 69, my lord. As an order passed under what 3161, whereby I was appointed as a member of the Public Service Commission. Now, apparently, my lord, some hesitations were going on, my lord, because in the earlier term, my lord, the earlier commission, there were some irregularities in the selection process.
Yes.
In any case, my lord, the government has done, my lord. The government has recalled these appointments that your lordships will get at page number 89 and 90, my lord.
Is it a competitive process in which you are appointed?
Yes. Yes.
Member?
As member, my lord. Page 89, my lord. Agenda item number 1. Proposal for recall of appointment orders dated 7/3/2023 in respect of selection made for chairman member of the Arunachal Public Service Commission. Decision. After detailed deliberation, the cabinet approved proposal for recall of appointment orders dated 7/2/20 in respect of selection made for chairman members of the Arunachal Pradesh Public Service Commission. So then at 90, my lord, in the interest of in the public interest, Governor of Arunachal Pradesh is pleased to recall the government notification appointing Rosie Taba as member. Now, my lord, the reason is given is that we have not taken oath. Now, that issue has been settled, my lord. Non-taking of oath, my lord, I may not assume the office and discharge functions. But, my lord, it will not invalidate my appointment. In order to invalidate my appointment, my lord, Article 317 has to be followed. My lord, there is a state cut authority on this point, my lord, where, my lord, 2018, my lord, 6 SCC 692, my lord.
Yes.
My lord will kindly come to page 694, my lord, the facts, first para. I think Honorable Justice Thakuri hasn't got them. Page 694 for the facts. Pursuant to a notification issued by the State Election Commission, UP on 21/9/15, elections were held to Khetra Panchayat, so and so. Apparently, results were declared on the same day and by the State Election Commission, and 63 candidates were declared elected. It may be mentioned that elections were held under the provisions of so and so. Then my lord will kindly come to para 6 at 695. In other words, a person duly elected to Khetra Panchayat under section 61B of Odhiniyam is described as and remains as elected member. And if that elected member do not take oath of office, he or she does not cease to be an elected member. The only consequence is that the elected member cannot take a seat in the Khetra Panchayat and therefore cannot participate in the proceedings of the Panchayat. The significance of this discussion will be apparent hereinafter. Then my lord will kindly come to page 699, para 24.
Yes.
That apart, there is nothing in law to indicate that an elected member ceases to be a member of Khetra Panchayat if he or she does not take oath of office. My lord, what had happened? The requirement of taking oath was initially not there in the regulation. By an amendment made in 2018, my lord, that particular provision was inserted, my lord, that your lordships will get at page number, my lord, 47, my lord. In March 2019, insertion of clause 4B in Arunachal Pradesh Public Service Commission Regulation 1988, after clause 4A, the following shall be inserted. Governor of Arunachal Pradesh or his nominee shall administer the oath of secrecy or to the chairman and member before entering upon their office on the following point. But it's a well-settled proposition of interpretation of a statute, my lord. If, my lord, no consequence is provided, my lord, then it has to be treated as directory, not mandatory.
Yes.
So therefore, in that view of the matter, in my humble submission, my lord, the learned single judge was not correct in refusing interim relief, my lord. Otherwise, tomorrow, the other selection process will be taken to its logical and they will be appointed. Then there will be people.
What is it? Just for our benefit, what is the process of selection?
Yes, my lord. And the learned single judge has refused to pass the interim order. That's why before lordships.
What is the process of selection, please?
As far as our concern, my lord.
Yes.
Yes. That process, my lord, will get. I think. Page number 64, my lord. Initially, there was a screening, my lord. Minutes of the screening committee meeting for screening applications received for chairman and member Arunachal Pradesh Public Service Commission held on 12th of January 23 at so and so. A meeting of the screening committee constituted by notification dated 11th of January 23 for securing the applications received for the post of chairman and 3 members of Arunachal Pradesh Public Service Commission was held on 12th of January 2023 at so and so. The following were present, so and so retired IAS, Dharmendra, Mr. Dharmendra, Chief Secretary Arunachal Pradesh, and Prabhashankar Shukla, Vice Chancellor Nehu. The committee was informed that the post of chairman and 3 members had fallen vacant due to resignation of the incumbent from the respective post. Accordingly, an advertisement was issued to fill up the aforesaid vacant post. In response to the advertisement, applications have been received from the following persons for the post of chairman and member of APSC in time. These are the different applicants, my lord. And page 65, screening committee carefully examined the constitutional provision, biodata as well as the work experience of all the 18 applicants for the post of chairman APSC and 58 applicants for the post of member APSC, and considered their eligibility to the post and responsibility they have to perform as per chairman and member. So my lord, article so and so is quoted. Then my lord will kindly see at page number 66, The committee, after detailed deliberation, and after taking into consideration of all documents placed on record, biodata of the applicant, age, length of service, qualification, relevant exposure, details of awards and recognition, NOC, etc., recommends the name of following applicant in alphabetical order for placing before the government for their decision. Lieutenant General Santanu Dayal, retired, for the chairman, and these are for the post of members, my lord. The recommendation of the committee is subject to clearance, etc., etc. And serial number 5 is the appellant before lordships, my lord. Then at page 67, proposal regarding appointment of chairman, member of Arunachal Pradesh. After detailed deliberation, the cabinet considered the proposal of the administrative department regarding filling up of 1 vacant post of chairman and 3 vacant posts of members of Arunachal Pradesh. After detailed deliberation, the cabinet approved the following names for placing before the honorable governor for their appointment. Shantanu Dayal, chairperson, Cornel Swenso, Pradeep Ligfa, and Rosie Tama. Then eventually, my lord, at page 69 is the order appointing the appellant before lordships. And in terms of Article 316, sub-article 1. Now, my lord, because of some hesitation going on, in fact, my lord, in one case, which is reported in 2013 5 SCC, some displeasure of the chief minister was there. Whether that would have been a German. Honorable Supreme Court says no, my lord. That judgment I'll just place, my lord. That is 2013 5 SCC, page 1. If a lordship will kindly come to para 120 first, my lord. Page 58. The question of the chief minister or the state government having confidence in the sense in which the word is used with reference to the chief secretary or director general of police or an important statutory post in the chairman of a state public service commission simply does not arise, nor does the issue of compatibility. The chairman of a public service commission does not function at the pleasure of the chief minister or the state government. He or she has a fixed tenure of 6 years or till the age of 62 years, whichever is earlier. Security of tenure is provided through a mechanism in our constitution. The chairperson of the State Public Service Commission, even though appointed by the governor, may be removed only by the president on the ground of misbehavior after inquiry by this court and on other specified grounds of insolvency or being engaged in any other paid employment or being unfit to continue in office by reason of infirmity of mind or body. There is no question of chairperson of a public service commission being shifted out if his views are not in synchronized with the views of the chief minister or the state government. Then at 125, my lord, there is therefore a great deal of solemnity attached to the post of chairperson of a public service commission. Chairperson takes the oath of allegiance to India and to the Constitution of India, not an oath of allegiance to the chief minister. An appointment to that post cannot be taken lightly or on consideration other than public interest. Consequently, it is not possible to accept the contention that chief minister or the state government is entitled to act on the perceived suitability of the appointee over everything else while advising the governor to appoint the chairman of the Public Service Commission. If such a view is accepted, it will destroy the very fabric of the Public Service Commission. So, my lord, therefore, in my and my lord, the reason of our cancellation is at page 85, my lord, which we obtain under RTI, my lord.
But the process was supposed to be completed when the fresh one. What is the stage of the fresh process?
Application, filing of application date is over on 2nd.
On 2nd June. Last day.
My lord, will kindly come to page 85, my lord. There's the note of the CM. Honorable Speaker, sir, as regards to the supplementary question of question number 40, which has been asked by the honorable member, Sri Nabam Tuki, in the floor of the House regarding status of selection of chairman and member of the Public Service Commission, Government had appointed the chairman and members already. However, there has been protest and aspirants by submitting a memorandum wanted that there should be a constitution of a new selection committee and there should be a new selection process for appointment of the chairman and member. Anyway, considering the popular demand, the appointment already made after taking the view of the learned senior advocate general, we have cancelled their appointment. Because though the appointments were made, but no swearing in had taken place, therefore the appointment has been cancelled. We'll discuss. So my lord, they say since oath was not taken, therefore it can be cancelled. And that's a view, is a flawed view, my lord. I don't think under the constitutional scheme, such a view is permissible, my lord. Therefore, my humble submission is, my lord, we have challenged our appointment before the learned single judge. But if, my lord, there is no restraint order, then
Yes.
my lord, it will become infractions.
Mr. Advocate General, yes, what do you say?
Well, the
Cancellation of appointment only by virtue of 317. There's no other procedure under the constitution.
one my lord submission.
There is no procedure provided in the constitution, recall of appointment.
My lord, the case cited by my learned friend, my lord.
Forget about that, we are not even going on to the judgments. Recall of appointment.
That relates to election, my lord. This is a selection.
317.
That is correct, my lord.
So is there any such?
We'll also kindly see, my lord, they have come for interim order. What interim order has been done? It is already granted in their favor, my lord. Your lordship will kindly come to page.
No, the interim order is stop this fresh process.
My lord, your
Consider
lordship
their
kindly see-
prayer,
everything
consider
is-
their writ petitions.
Everything is made subject to the result.
No, there can't be. Then you'll want two functional bodies at the same time. What will happen if there are fresh appointments?
Your lordship may direct, my lord. I humbly submit, my lord, that the matter we had, because that is what was fought for by the.
You stop the fresh process, sir. That's what the
My
only
lord,
order.
those are not parties here, my lord, because 2nd of June, my lord.
They have not got any right as of now. No right is accrued in their favor.
The instructions, your lordship.
Only filing application, does it give any right to anyone?
My lord, today is 8th, my lord.
Yes.
And we don't have the instructions as of now, my lord.
That you have made the selections
Let it be taken up on
at
tomorrow.
at 2.
Tomorrow, my
Even no, absolutely no, sir. Get the information on phone.
At
It
2,
takes
my
a
lord.
moment.
At 2, my lord.
Mr. Goswami, it takes half,
At 2, my lord.
15 seconds it takes. Go out, get the information right now. Otherwise you'll make the appointment in between. We are sure that will happen.
No, my lord, we have taken, my lord, 2 weeks to file affidavit, my lord, so that is already on record, my lord.
You get the information right now. We are passing it over. This is totally an illegal action we have taken.
Let it be taken up at 2, my lord.
15 minutes.
My lord,
States.
your lordship,
Get
with no appointment.
Get
will
an
be made.
instruction on phone, sir, right now.
It depends only on the person concerned is available. That's what, nothing.
It takes hardly 15 minutes.
My item is.
You should have advised as a matter of fact.
Well, they also been given the liberty to, my lord, participate in the subsequent.
Oh, why should they? They are already selected. Whether the selection can be cancelled, does the constitution talk of that? You want that constitution should not
Normally, my lord.
get an exception.
Supreme Court also says, my lord, the discretion of the state government is not, my lord, interfered with, my lord, in the very case, my lord.
Discretion to do what? To violate the constitution.
No, my lord, in matters of appointing members to, my lord,
So whether the state can itself tinker with its own discretion, having
There was an
appointed.
issue behind it, my lord, because there was large scale, my lord, paper leakage, my lord. The two
Yes,
cases
but
have
they
been
were
taken
not
to
even, they were not even there.
CBI.
These people were not there when the paper leakage took place.
Well, I'll just take the instruction.
You see, this reason by itself is flimsy. The paper leak took place in the erstwhile regime. They are freshly appointed, selected. They didn't hold the office for a single day.
That is correct.
Now, what is the premise for cancelling their selection?
Let me get the instruction.
That is the reason which is given out in the answer given by Honorable Chief Minister
That is
on the floor.
That is.
Paper leak, representations. Yeah, you also are there.
My lord, item 36 is mine. Same,
Yes.
same issue, absolutely. I'm for the another member.
You are for the member.
Two members.
Two members. This is the point I argued before the single judge also, that there's no power to recall. Anyway, my lord.
I'll get the
Or you yourself get an order passed, putting your process on hold. That will be a face-saving device for you.
Let me get this.
Rather than this court being compelled to pass the order, it will be a better face-saving device. Get it adjudicated, then do whatever you want. Yes.
Item 38.
Against an order, my lord, without giving any notice in regard to elections of pharmacy council, members of the pharmacy council.
Election
of pharmacy, 6 members of the pharmacy council, my lord, that whether by the postal ballot or by the digital mode. Court order is at page 86, my lord. Evidently, my lord, no notice was given, neither was heard, my lord. The first day itself in the motion day.
What do you say, sir?
My lord, it may be sent back as your lordship wishes. It may be sent back to the, but till then, till disposal of the writ petition, no election on the digital mode.
No?
No election on the, by the digital mode.
No election by the
Digital mode, because the whole contention is there. That the
digital mode.
digital mode.
My lord, as per rule 8.2, my lord.
Yes.
There is a page 150. There is a process for holding the election by postal ballot. So now 1,000 members are there. We said it is difficult to do. We went to government. Government exercise power under Rule 23.
You pray for an interim. You make your interim prayer before single judge.
Because digital, how they are prejudiced, my lord.
You make a prayer. We are remanding the matter to the single bench. Make a prayer for interim relief there.
Only the,
on the
Mr. Das, till the writ petition is again decided, don't proceed with the elections till then. What is the problem?
We are not doing. Government is, in the meantime, government has permitted us to not to go for the election on digital mode. That means everything by WhatsApp, all members will get notice, and there will be more participation.
Process apparently is flawed, sir. There's a huge chance of hacking and everything being done in that.
No, but postal ballot people will not get it. But anyway, in the meantime, government is planning to change the rule also, and it is likely
So
to be
till
done
then, don't hold the elections. What is the problem? We'll remand the matter back. Say that the things will be put on hold till the writ petition is decided.
Yes.
Okay.
Yes. Till the decision is taken.
Till the decision is taken.
Interim.
Disposed of.
This order will be set aside.
Of course.
This
is item number supplementary 30. Okay, just talk. ये pronouncement अपने यहाँ पर है क्या? यहाँ क्यों लगाया है? This he could have done, but then it is listed here. Then it has to be pronounced here. 2 बजे का बोलिएगा उनको, मैसेज करिए. भेज दिया जब आपने लिस्ट में शो किया है, तो यहाँ प्रोनाउंस होगा. Otherwise उनकी लिस्ट में शो होना चाहिए. I didn't know that it has been listed. Then give an instruction that it has to be pronounced in DB. रजिस्ट्रार को कुछ समझ में नहीं आता है. Yes, कॉल करिए.
Daily list. Item number 20 to 22.
Lordship on last occasion asked us to get the entire case record, Lordship. Lordship, we have received, but as per the note sheet, some records are not there, Lordship. So I have again called them. If your Lordship can
Ms.
be taken up
Bhattacharjee
at 2
submits
o'clock,
that
Lordship.
she has not been able to collect complete record required for disposal of these 3 writ appeals. She prays for and is granted further opportunity of 4 weeks to do the needful.
4 weeks. Because you're not with the method, you're not.
Now it's just nothing is possible, sir.
After
vacation it goes. List after summer vacation. Parted ले लीजिए, parted call कर लीजिए. आपने वो वहाँ information कीजिए that this has to be pronounced here, then the bench has to be formed.
Supplementary list per third matter, item 39.
The lordship has substantially harmed the matter, Your Lordship.
Yes.
Last occasion, Your Lordship. The councils for the, Your Lordship, school managing committee wanted to place the records, Your Lordship. The council for the school managing committee wanted to, Your Lordship, place the records.
Yes.
Election, Your Lordship. So far as my
We'll just recapitulate what was the argument, please. Mr. Chetri, you may please.
Yes.
Yes.
Malad,
उसमें डालिएगा वो जो ये था ना रिजर्व किया उसमें.
here, Malad, in the case, Malad, Lordship will find in the judgment itself of this single bench, honorable single bench, Malad, where in para 10(4), clause 4, Malad, page 121.
Para 10.
Para 10 of page 121, Malad.
Yes.
For ready reference, the
Vice principal, you say that the vice principal was there,
yes,
which was
and that
an illegality.
that has been filled up by
that-
one vice president.
Vice president.
Yes,
Yes.
and that apart, my lord, Lordship will find the president will be the managing committee, the chairman will be the president of the managing committee, and member, one vice principal, oblique a postgraduate teacher in case of higher secondary schools, or assistant postgraduate teacher in case of high school, and one parent to be nominated by a managing committee, and member secretary, the principal,
oblique
headmaster of the school. And there is a government order, my lord. Instead of the principal being the candidate of the principal, my lord, then the inspector of his school has to notify. That order is there, my lord.
At
This is the order, my lord,
yes.
passed by the Director of Secondary Education, where queries have been received as to who will discharge the function of the school selection committee as member secretary in case in charge principal himself is the candidate for the post of principal of the school. In such cases, the inspector of schools will notify a postgraduate teacher having master degree with B.Ed or a senior most graduate teacher having master degree with B.Ed to
As
exercise the
to
function of the
function
member
as a member
secretary.
secretary, yes. Herein,
Of the-
who acted as the member secretary?
Now, one postgraduate teacher, she was appointed, she was inducted as member, as well as she also acted as member secretary, and there was no such notification.
Member as well as member secretary.
Member secretary, they have stated, my lord. But in the
Why a member was required? Because the vice president acted as the member 1, and the parent was there as member 2. So where was the requirement of a third member?
Where
Where is the
no one
composition of the committee?
Yes,
Let us see.
Lordship. The composition Lordship will find.
Yes.
Lordship will find at judgment of the single bench, my lord, honorable single bench, page 120, my lord.
Para.
Page one, para 6, my lord.
Yes. Member parent.
Uh,
So
that-
where the
Chairman, Dr. Kukil Borua, President of SMDC. Member Sri Rupok Deka,
Vice President.
Vice President SMDC. Member one parent to be nominated by SMDC. And another member secretary, Binapani Mohanda, subject teacher.
Yes.
And here, my lord, this member, Rupok Deka, he cannot be the member.
Yes.
The rule.
So if the vice principal is not available, the postgraduate teacher has to be appointed.
Yes.
So was there a postgraduate teacher in the school?
Yes, there are around 8 to 9 postgraduate teachers.
Okay.
And
the member secretary also, you say, was not the he was only the subject teacher, not a teacher having master degree with B.Ed.
Yes.
That is the argument.
Master degree, my lord, here chairman is all right, my lord. The member Rupok Deka is
that is illegal as per you. Yes.
And member one parent to be nominated, it's correct, my lord. And member secretary, that in case of the principal in charge being the
contesting
candidate of the selection committee for the post of principal, then for the member secretary, the inspector of schools
has to nominate.
Notify.
There has to be a nomination.
Yes, for nomination, my lord. That is not there, my lord.
Yes.
One way, the statutory provisions of rule has not been followed, and another way, the government instruction, the order, which has been which has to be notified by the inspector of school, that has not been followed. And accordingly, my lord, when this
how has the learned single judge dealt with this?
Learned single judge, my lord, there are 2 queries, my lord, regarding the
vice principal,
this
member secretary. No,
yes,
the member vice president.
There is a 2 question arose, my lord, before
Yes.
the single judge.
Yes.
Regarding violation of the provisions of rules. Secondly, they also come with the plea that since petitioner has participated in the selection, so she cannot come back and challenge the selection. And that part, the second part, this single bench did not say anything else, my lord.
Okay.
Did not utter. Since there are so many decisions I have placed, my lord, so that participation, the single
For
judge
that, our observation was that unless the candidate appears before the interview board,
yes,
the candidate cannot know the composition.
Yes, that is the point, my lord.
Yes.
And that is why, my lord, now since this second part, the single bench has not said anything else regarding estoppel of the petitioners. The only point arose before lordships is that whether that in violation of statutory provisions of rules, whereby
Doctrine of necessity was relied upon. Yes.
the lordship will find the view expressed by the honorable single judge, my lord, at page 20.
Para 20. Para 20.
Para
Yes.
20, page 124. my lord. The reading of the writ petition would show that as regards of the first ground of challenge from the date of interview, that is 8/11/16 till date of filing of the writ petition, there is not even a whisper regarding violation of the rules. Regarding constitution of the selection committee, school selection committee, a whisper.
Yes, what do you say? Okay. Yes.
Lordship, so far as my case is concerned, your lordship,
You are the selected candidate.
I am the selected candidate, your lordship.
Selection
And
has
my
to be held afresh,
selection-
sir.
My selection is your lordship, my selection I came into picture, your lordship. I was on initially, your lordship, not at serial number 1, your lordship. The existing principal in charge in serial number 1, I am at 2 and she was at 3, your lordship. And in the meantime, when the results were declared, by the time it took, your lordship, around 5 months, your lordship. And in the meantime, the person at the serial number 1, your lordship, in the
Retired.
place, he got retired and I came into picture, your lordship. Now, your lordship, the honorable single judge, if your lordship looks at para 20, your lordship
We
will
have seen
find,
it.
your lordship.
Very
has-
flimsy findings.
No, your lordship will kindly see, your lordship, that the presence of your lordship, first of all, this Rupok Dekha.
Where from do we get it that his presence was just as a supervisor? No effective participation. He did not give marks.
No, your
But then why he was there?
Not
He shouldn't have been called.
Not supervisor, your lordship, as a facilitator, your lordship.
But why? What facility? Does the rule call of
No.
require or mention that any person can be present as a facilitator?
As a facilitator.
You see,
your
in
lordship-
China, what happens is the courts are functional, but the members of the party, they sit nearby.
Lordship,
So they are facilitators of the judgments.
that's a different matter, your lordship. That's
That is
secondary.
what Honorable Justice T.S. Thakur, he visited China and he gave a speech wherein he mentioned this. They are facilitators of the judgments.
Lordship, that's the country is
So
like
that
that,
is-
your lordship. Now, secondly, your lordship, so far as my case is concerned, your lordship,
Yes.
what has been the finding of the honorable single judge?
We are not on your case or his case. We are on the fact that the selection committee was illegally composed.
No, your lordship will kindly see, your lordship, the finding of the honorable single judge.
Yes.
This, your lordship, that first of all, your lordship, she is not prejudiced, your lordship, number 1. Number 2, your lordship, that your lordship, the marking pattern, your lordship, marking pattern is such,
Marking
your lordship, the
pattern by
subjective satisfaction is
a
not there.
committee which was not competent to award marks. So what is the marking pattern going to, how the marking pattern is going to save the day?
Ultimately, your lordship will kindly see, your lordship, that the committee constituted, your
So
lordship.
why do we need to read the rule at all? Do it as per your whims.
No, your
Place
lordship,
any 4 persons
secondly,
as per your choice.
No,
Get
your
the selection done.
first of all, your
This is a
lordship,
rule of law. If it is not followed, the procedure has to be struck down.
what has fallen from your lordship, not is your lordship, I admit, your lordship, but admitting that, your lordship will kindly note, your lordship, whether she is prejudiced or any malice is there or not.
1985 Supreme Court, A.K. Roy versus State of Punjab.
And secondly, your lordship, this is also, this aspect, your lordship, honorable single judge did not take note of, your lordship, that having participated, even if there is a.
Mr.
your lordship will
Kotakur, tell us, was the composition advertised in advance? Who will be members of the committee?
No, your lordship.
No, then what measures did she have to know who will be sitting in the committee?
Lordship, once she having seen that, your lordship.
Oh, then she will come out. No, I'll not participate.
She should not come out, but she should have, your lordship, raised that issue, your lordship, before.
That no, you are not competent to conduct the interview.
No, your lordship, before the state selection committee, your lordship, there are 2 types of committee, your lordship. One
Yes,
is the
all right.
School selection committee, then it will go to the state selection committee, but he remains silent. And if your lordship go through her representation, her claim is that since I am senior, I should be allowed to.
If the infrastructure fails, the superstructure fails.
No,
that is the principle.
No, that is there, your lordship. But your lordship, here, your lordship, had she been prejudiced, she knows very well that this person has not, your lordship, even asked a question, your lordship. Therefore, she is not aggrieved. And as an
What
afterthought
was
for
he
the
sitting
first
for,
time
sir?
in the petition.
What was he sitting for? Was he a Ganeshji?
No, your lordship.
That any
he
puja
is-
starts with by remembering him?
He is a facilitator, your lordship. He is compiling these documents and handing over it, your lordship. There's
You
nothing
could
more
have-
than that.
You
So
could
far
have
as-
called a LDA
That-
to compile the documents.
That is
Why
your
did you need a vice president?
No, that is your lordship, the school selection, school authority can, your lordship, answer, your lordship. They have, your lordship. I cannot answer that, your
All
lordship.
right,
I am a
let's see the
participant, your
school authorities, yes.
lordship. So far,
We'll ask,
just
just
one
hold on.
judgment, your
No,
lordship.
you've given us that option.
No, one.
We'll
one-
ask the state authority, school authorities, yes.
One judgment, your lordship, I want to place, your lordship, that.
And in the minutes of selection, he has signed, madam.
Judgment on what issue, sir?
Lordship, this issue, your lordship. After participating, your lordship.
Ah, yes, we know that there are hundreds of judgments.
Lordship.
Mr.
And
K. N.
even-
Chaudhary has educated us on that view.
even if there is infraction of rule, your lordship, even then, your lordship, that
The
cannot
selection
be.
has to be saved.
Lordship,
by
since she
any such-
participated, she does not raise any
All right.
objection at any
Okay,
point
we'll
of
deal,
time.
we'll deal with that, Judge.
Lordship, lordship.
Okay.
That your lordship will kindly
K.
take note-
Manjushri.
take note of your lordship. This is your lordship.
Yes.
Okay, did you-
Read this judgment. Before you proceed to argue anything,
Lordship.
read this judgment, para 10 where we have marked. Read para 10 where we have marked.
A careful analysis of the language of section 21 of the Act.
This
really
second column we have marked the para.
Lordship. The provision contained in
No,
section.
no. Para 10,
Para 10. your
second column.
Lordship. Where power is given to do a certain thing in a certain way,
Yes.
the thing must be done in that way or not at all. Other modes of performance are necessarily forbidden. The intention of the legislature in enacting section 21 was to confer a power on the authorities specified therein, which power had to be exercised in the manner provided and not other. Your lordship, that
So
is
the
an
rule
exception.
provides
Your lordship,
composition of the
that is
committee.
there, your lordship,
It
but-
can't be done in any other way.
But that is there, your lordship, but at the same time, your lordship, these judgments, your lordship. 2008.
So there are judgments to the effect that if there is a certain condition in the advertisement which is contrary to the rule, that can be challenged even after participating.
Your lordship,
There are
kindly
judgments
go
to that
this,
effect
your
also.
lordship, 2008 4 SSC, your lordship.
Yes.
171. Para 9, your lordship, small paragraph, your lordship, small judgment. And this has been relied in your lordship, another judgment, your lordship, of forum of three judge bench, your lordship.
Yes, yes.
In the present case, as already pointed out, the respondent and petitioner herein participated in the selection process without any demur. They are stopped from complaining that the selection process was not in accordance with rules.
Selection criterion. He is
Selection-
not challenging the selection criteria.
Selection process was not in accordance with rules.
They are stopped from challenging the selection criterion. She is not challenging the criterion. Says the composition of committee is illegal. It's illegal for all purposes.
And your lordship, the
The selection was undertaken by an incompetent body. That is a simple argument. You won't find any judgment which can save it.
that your lordship, so far as one division bench judgment, I have relied on your lordship of this honorable court, your lordship, where your lordship exactly similar identical issue was concerned, your lordship, and it has been held. Your lordship, that judgment, your lordship, other day I have handed over your lordship.
Yes.
They are specifically
Yes.
held that your lordship, once she participated, now she cannot, your lordship, turn around and say, and
Okay.
here is a case, your lordship will kindly note, your lordship,
Yes.
that she waited, your lordship, for results to be declared, your lordship, and after that,
Or-
your lordship, 5 months after the selection was completed, your lordship, when the results were declared, your lordship, she came up before this honorable court, taking that plea for the first time, your lordship.
Yes,
And
very
your
well.
lordship, had she been prejudiced, your lordship, had there been any malice, your lordship, they would have raised that issue, your lordship, before the state selection committee also, your lordship.
Yes.
She did not raise that point before the school selection committee also, your
There is a contrary judgment of by same honorable judge, which has been cited by the petitioner appellant side.
That your
So that judgment was not considered. So the later judgment is per incurium.
lordship will kindly see, your lordship, the earlier judgment, your lordship, this issue was not raised at all, your lordship.
Okay, we have
That
heard
the
you.
issue
Thank
of
you.
your lordship, your
Okay,
lordship.
thank you. Yes, school. Yes. Whether your selection committee was properly composed.
Irregularly happened, my lord, but not illegal, my lord.
Okay.
Because my learned friend has submitted, my lord.
Yes.
My Learned has submitted, my lord, that as per rule 8(4), my lord, committee has been constituted. One person is there, my lord, Rupak Deka, he was a facilitator. That irregularity took place, my lord, I admit. But thing is,
Irregularity by what measures do you call it? An irregularity
I'm coming,
and not an illegality.
Us-
Person who was not entitled to become a member of the committee,
Yes, sir.
he is introduced. How is that an irregularity?
He was sitting as a my lord facilitator.
Or did you record it in your minutes that he will
No, my
be
lord.
facilitating, he'll be doing the clerical
One
job?
thing, one
Why
letter.
did he sign the result sheet?
Yes, my lord. One letter is there,
Counsel.
my lord, record that he was appointed.
Why did he sign the result sheet? In what capacity? Does your result sheet says
Yes,
that he is a facilitator
In-
signing in capacity
Yes,
of,
my lord. In comprehensive result sheet, my lord, he put the signature, my lord. That I
why,
admit.
in what capacity?
That is irregular.
Facilitator or a member?
As a facilitator, my lord.
Is
irregular
it
to press.
mentioned?
I am in that number, one letter, my lord, 7/11/2016, my lord. Your lordship kindly come to the my lord, that my lord.
Yes.
That notice, my lord, one notice has been issued by principal in charge, my lord.
7/11/16.
Yes, my lord, 11/11.
That is after the selection process.
That, my lord. No, selection was no?
That took place in June.
Yes, my lord. 2016.
Yes. 7/11 is after the selection process. Long after.
No, my lord.
No. Are you
No.
sure?
Sure.
What is the date of the selection process?
Yes, ma'am. May I read that letter, my lord, sir? With reference to the only, may I read that letter? Page, my lord, this is I from reading from record, my lord.
No, no, no. Nothing on, no, something which is not here
Yes,
on the
my
file will not allow you to read.
Ultimately, my lord, what happened? The number is, my lord, given in objective way, my lord, not subjective way, my lord. Your lordship kindly, I.
Presence of an extraneous person in the committee
Yes, my lord.
vitiates its composition.
That is not materially affected in the selection, my lord. Lordship kindly go to the, my lord. This I have prepared, my lord. Why 1 mark has been get more by the.
Mr. Counsel, we are not on the manner of evaluation
Yes,
at all. We are
And
putting you a
I
simple
have a one
question.
judgment, my lord. I try to satisfy your lordship, my lord.
Yes,
Judgment,
sure, sure.
No, no, okay.
Carry on. We have also given you one judgment. What is required to be done in a particular manner as per the statute.
That not, my lord. May I read my lord, that judgment, my lord?
Yes.
2016 1 SSA 454.
Yes, 2001 SCC 454.
454.
What is the ratio?
The quorum is 2 judges, my lord. I am coming, my lord, paragraph, my lord. 16, my lord. First, Madanlal has 14, paragraph 14, my lord.
Yes.
Madanlal has already been discussed, my lord. Your lordship has said about this Honorable Justice Sanderson's judgment, my lord, recent judgment.
Yes.
That how the rule should be, my lord, framed, my lord, on that particular way, selection should be granted.
Yes.
If the selection body has been constituted contrary to the rule, my lord,
yes,
that cannot be done. That judgment, my lord. I'm reading, my lord, the question whether who is consciously take part in the process of selection can turn around question method of selection is no longer res integrator. And then Madanlal discussed, my lord, and Monish Kumar Sahi has been discussed, my lord. I think this is it, my lord, 3 judges bench. We also agree that High Court, after having taken part in the selection, knowing fully well, more than 19 mark has been earmarked, or 5 repetition are not entitled to challenge the
Based on
criteria.
Estoppel.
Yes, my lord.
Yes, many judgments have been cited.
Yes, my lord. This is for the Estoppel, my lord.
Yes.
And my.
We have posed a simple question time and again.
Yes, my lord.
Whether the candidate knew the composition in advance.
My humble submission before your lordship is that, my lord, that after the selection, he appeared in the interview board, my lord. He has never raised this question in the.
The argument which is being raised is after participating, the challenge is given. We are putting you a question. Now, this is the probably 7th time. Could the candidate have known in advance what will be the selection committee composed of?
Yes, ma'am. My humble submission, my lord, before your lordship is there.
At least try to give out some.
In his repetition, nowhere he stated, my lord, that it is not within his knowledge
the selection.
That is a presumption, Mr. Counsel,
Yes, my
that you will not disclose
Mhm.
the composition of the selection committee
Yes, my
in advance.
Yes, my lord.
So as to maintain the sanctity. It's an interview board. No one is supposed to know what the interview board will be comprised of.
Yes, my lord.
Okay, thank you.
That, my lord, my humble.
You already argued now. No more opportunities.
That my humble submission.
Hold a fresh
as a
selection.
lordship, like my.
Yes.
My lord.
Anything,
My humble
anyone
submission,
else?
My submission, my lord, your lordship may record my submission.
Of course, we'll take note of it.
In the writ petition, nowhere the learned counsel for the writ petition, it was pleaded case of the petitioner that he does not know the composition of the body. That was not it. And even he in page 49 filed a representation. In that representation, he was silent about all these things. And my humble submission, it is irregular because it is not illegal, my lord, irregular.
That you
Only
already said,
Rupal
sir.
Dutta is appointed as a.
That is already you have made this submission.
Yes, my lord. I am
Okay.
repeating this submission, my lord.
Very well.
Yes.
Thank you.
Yes, sir.
Yes. Anyone else? Sure. Okay, very well.
And that last judgment I read, my lord, that other part, my lord, quorum is 3 judges, my lord. What judgment has been read by my learned friend is quorum is 2 judges, my lord.
No, I have also 3
And-
judges.
And my lord, if the 3 judges judgment, my lord, official liquidator will follow, my lord.
Lordship, if your lordship,
That judgment is available.
Lordship interpret with the judgment, your lordship, my further prayer will be your lordship, that since it is an insert basis, it is going on. It is insert basis, it is going on, your lordship may direct for your lordship filling up the.
Yes, we'll direct them to hold the meeting to conduct the fresh process. Complete it quickly. Yes.
One mark get by the Bhattakur client, only because of that Bhattakur client got medal. And his client has not got medal, my lord. Objectively, it is not affected, my lord. Because it was subjectively, my lord, not made, it is objectively made, my lord.
Gentlemen, it can't be done on whims of people.
Yes, my lord.
That is why rule of law prevails.
Yes, my lord.
Arguments or judgment. You can give a brief note, please.
Yes, my lord, some of the judgments are there, my lord, 3 judges, I would supply them.
A brief note also.
Yes.
Yes. Yes, Ms. Goswami.
We couldn't talk to the concerned secretary, my lord, but anyway, the instructions I have got that they have not taken any decision, but applications have been made for both for the post of chairman and.
Yes, applications must have been.
Including by the petitioner in the Mr. Bojumdar's case, for both for chairman and for member.
That would be.
And the other selected member, Lingfa, who has, to my knowledge, not filed any writ petition, he has also applied. So in this case, my lord, at least so far as Colonel Coase is concerned.
We are staying the entire process.
Well, 317 for a person who has taken oath of office, my lord. Your lordship, the language is quite clear in the constitution.
Yes.
Here, the oath of office has not been taken.
Yes. But does it stipulate any
And the case
procedure
cited, my lord.
for cancellation, sir? Does it stipulate any process for cancellation?
Certain, my lord, play in these lines, my lord, your lordship will allow to the government in their discretion, my lord. That is also said by the decision cited by my learned senior friend, my lord. In that case itself, my lord. Normally, they should have discretion.
Discretion to cancel a duly made selection.
My lord, reasons have been are before your lordship that your lordship has to take a decision on that, my lord.
Yes.
And
No, let the writ court, Goswami, we don't comment on the merits. Let the writ court decide the writ petition at least. Till then, you don't go ahead with your selections.
Otherwise, my lord,
You don't-
interim protection is given.
Don't, if you take our reasoned order, that the constitutional scheme doesn't provide for cancellation of selection, then your writ will be fait accompli.
Yes, but as of now, as the case stands, my lord.
Yes.
Our stand, my lord, we are possibly not attending, we are filing affidavit and the court will decide only then because everything is made subject, my lord. To the result of the.
What is the anxiety to hold a fresh process till the writ petition? What is the anxiety to hold a fresh process till the writ petition is decided then?
Your lordship may direct some short date, my lord, so that they will decide it before that, my lord.
And all right, then you make a concession.
My lord.
You make a concession then.
That concession, my lord, I cannot give, my lord.
That will not proceed with the process.
I would rather, my lord, I would rather pray that my objections be recorded in this case, my lord. Whatever order Your Lordship, may
Oh, yes, definitely we'll do that.
number one is, my lord, I am.
Then we'll record our reasons for doing so.
My lord.
Then we will record our reasons for doing so.
No, my lord, what I'm submitting is, my lord, the number one, my lord, the case cited by my lord, a senior friend, is in case of election, my lord, that people's mandate is concerned.
Yes.
Here it is not that fact. And the 317 will come only in respect to a person who is not only selected and appointed, but has taken oath of office.
Okay, let's see the provision.
My lord,
Read Article 317.
Yes, my lord.
Read.
May I read, my lord?
Yes.
Removal and suspension of a member of a public service commission. Subject to the provisions of clause 3, the chairperson, chairman or any other member of a public service commission shall only can be removed from his office. Your lordship kindly know, from his
Yes.
office by order of the president on the ground of misbehavior after the Supreme Court on reference being made to it by the president has on inquiry held in accordance with the procedure prescribed in their behalf under Article 145. Reported that the chairman or so and so. Then the president, as the case of the union commission or a joint commission, and the governor, in the case of a state commission, may suspend from office the chairman or any other member of the commission in respect of whom a reference has been made to the Supreme Court under clause 1 until the president has passed orders on receipt of the report of the Supreme Court on such reference. Then 3, my lord, notwithstanding anything in clause 1, the president may by order remove from office the chairman or any other member of the commission if the chairman or as a case is adjudged and insolvent, engages during his term of office in any paid employment is in the opinion. So, my lord, the reference is to a person who is already holding an office. That
After appointment, what else is to be done?
the oath, man, oath of office, which is brought by the amendment, my lord, in
Constitution doesn't talk of any oath. That's a formality which the state government has prescribed. So if you are arguing that mere administration of oath is the only ground on which, only way in which the selected candidates can hold the office, then probably that will again have to be examined. Constitution doesn't talk of administration of oath.
That may be, my lord, that's open for examination.
So then you are now again think over it. You want a reason order prejudicing the outcome of the writ petition. You're free to do so.
But my submission, it is already they are well protected, and we are not going to pass any
Mr.
order.
Goswami, now you take a decision right now,
My lord.
or come back at 2 and give us an indication that you want a reason order. You want to challenge it? Yes, you are. Are free. We'll record our reasons. We can, yes. Because the better way out will be get the writ petition decided. Till then,
Yes,
don't
sir.
proceed. That's the reasonable thing to do. Because they
That
had
is
no
also-
option but to apply once the stay was denied. They had no
My
option.
lord, I am opposing stay. It is not the fact that we are going to appoint, my lord, in the meantime, by taking advantage of that, I can make myself clear. my lord.
No, you have to withhold the process. Don't create third party rights.
Exactly.
Yeah, yes, my lord, obviously.
So then the stay is the only way out.
Yes.
Come back. Yes. Initial part लिख लीजिए. These two intra-court writ appeals are preferred against the order dated 8/5/2023 passed in orders dated 8/5/23 passed in WPC number 213 within bracket AP/23 appeal का number लिख दीजिएगा. Writ appeal number pertaining to writ appeal number 205/23 and WPC number 223/23 writ appeal number so and so. Yes.
My lord, the secretary is in Delhi, my lord, tomorrow 10 o'clock, can this matter be taken up? 10 o'clock, my lord, first item.
Let him have that much of opportunity.
He is smiling, my lord.
Why won't he smile? We have given our opinion.
Fast item, fast item.
You can put a restriction on his smile also.
I'm grateful.
On the request of Mr. Goswami and Additional Advocate General, Arunachal Pradesh, come on, list tomorrow. With the understanding that the matters shall be taken up on priority. Deeply.
For hearing daily list, item 23 and 24.
Hello, none present.
May I please, your lordship?
Yes.
I did to item number 23, 24, and 30. The engaged counsel was expired, your honor. So the petition will engage another advocate. So
It is stated that engaged counsel. Who? What's the name?
Mr. N.N. Karmakar.
Mr. N.N. Karmakar has passed away in this comma. The appellant petitioner shall be required to engage another counsel to argue the writ petitions. So for 6 weeks time is granted to the petitioner for engaging a counsel of choice to argue these writ petitions and the writ appeal. Writ petitions, writ appeal में अलग order लिख लें. List after 6 weeks.
Your lordship, item number 23, 24, and item number 30.
Yes.
Deeply obliged.
अलग order हो जाएगा ना 30 में अलग order.
Item number 27.
Matter was called out, none present for the petition. List after 2 weeks, 6 weeks. अच्छा है ना? Yes. Should we hear the matter or not?
Today I am praying for little accommodation.
Why?
It is some personal.
We become habituated to argue on behalf of the state. No stakes.
No, madam.
What is the writ appeal about? Just
this is regarding the learned single judge was pleased to interfere with her appointment, my lord.
In the appointment of the appellant?
Yes, madam.
Okay. Very well. Ms. Khatnia, please for time. List. Appointment as
Excise constable. Excise constable, madam.
Excise constable. List after 4 weeks.
They are enjoying the.
List. They are enjoying a stay.
Lordship.
Oh, that's the reason for adjournment.
From 2018, lordship.
Then, Mr. Khatnia, there is no valid ground to.
Without my consent.
Earlier, Mr. BD Code, Senior, he was representing the respondent, private respondent.
Why you are bothered? Who is representing respondents?
I was not aware about that. Recently, he has been involved.
Why you are bothered? The respondents. You are to argue your case.
No, he said that without his consent, because I was not aware of that. That's why.
Forget about that. Today he says that you are enjoying a stay from 2018.
Yes,
Some 16, 5/2018, lordship.
Yes, that is dear, my lord.
Then,
Entire process is illegal, lordship.
how were they appointed? What is illegality in the process?
Because, my lord, initially they filed a writ petition, my lord.
We are asking you what is the illegality in the process?
Yes, my lord. The thing is that, my lord, our age was condoned.
Condoned?
Yes, my lord.
Age relaxation?
Yes, my lord.
Okay.
That is the illegality they are talking about, my lord. Nothing else, my lord. We have participated in the selection process. We have participated in the physical test.
Condonation was before selection or after selection?
Before selection, my lord.
Okay.
Before participating in the selection process.
And is there a power with the authorities to
Yes,
condone
there was
age
no
relaxation?
office memorandum, my lord. On the basis of the office memorandum, my lord, our age was relaxed, my lord.
Okay.
That is the only.
So let then come on 20th June.
Yes, my lord.
Mr. Khatnia, please put time to argue the matter list on 20th June. Okay.
Item 28.
My lord, my senior has left the court, my lord, because his stomach trouble, my lord.
Arguing counsel is reportedly indisposed. List after 6 weeks.
Okay.
Item number 31.
May I please, your lordship? Lordship, pursuant to the status report filed by the respondent authority, we don't want to praise the appeal. They have already
Counsel
completed.
for the writ appellant states that in view of the status report filed by the respondents, wherein what is the
80% has been executed, lordship.
which indicates that 80% of the work under the tender, under the contract in question has been executed, comma, his client would be better advised not to proceed with these proceedings. In view of the submission so made, comma, the writ appeal as well as the IA civil are disposed of as withdrawn.
Lordship.
Item number 33.
Advocate General. Yes.
2018.
May I please, your lordship, here the writ appeal has been prepared against the common judgment and order dated lordship 27/12/2020 in respect of 45229 of 2019 writ petition.
There were more than one writ petitions.
Two writ petitions.
What happened in the second one?
The issue is that lordship, here the petitioner, the respondents, the petitioners have obtained their degree in engineering through distance
learning. Okay.
And lordship, they were in-service candidate. And as per the PWD Engineering Service Rule 1978, section 11(4), if any one of the sub officers.
Mr. Chaudhary, we are putting you a simple question. What happened in relation to the second writ petition?
Second writ petition, because lordship, with regard to the apex court judgment, they passed out the validity test conducted by the AICT on their first attempt. And whereas
So their services were regularized.
And they were whatever benefit they got under the rules, those continued, lordship.
Okay.
In respect of the respondent here in lordship, they obtained their validation on their second attempt.
Okay.
And as per the apex court decision, that will be they will get the benefit of their degree from the date they obtain the validation. Whatever benefit they was accrued to them beforehand, those will not continue.
Okay.
And here, lordship, the single judge, learned single judge, disregarding the clarificatory order passed by the honorable apex court, lordship, directed that their degrees are valid and they should be given the benefit as per the select list of 2017. Lordship, that is the
which is the Supreme Court order you are referring to?
Lordship, one has been annexed 2018 1 SCC 468.
Okay.
Or lordship can have the book, lordship, they need to. 2018 1 SCC 468.
It's annexed at page 83.
Yes, lordship.
Judgment is there on the file.
Yes, lordship. Here, lordship, the direction were given in paragraph 57 and 58 at page 153, lordship. Lordship, may I read it? Having found the entire exercise of grant of ex post facto approval to be incorrect and illegal, the logical course in normal circumstances would have been not only to set aside ex post facto approval, but also to pass consequential direction to recall all the degrees granted in pursuant thereof in respect of courses leading to award of degrees in engineering. However, since the 2004 UGC guideline themselves had given liberty to the deemed to be university concerned to apply for ex post facto approval, the matter is required to be considered with some sympathy so that the interests of those students who were enrolled during the academic session 2001, 2005 is protected. Here, lots of the respondents were during this period.
Okay.
Though we cannot wish away the fact that the deemed to be university concerned flagrantly violated and entered into areas where they had no experience and started conducting courses through distance education system illegally, the overwhelming interest of the student concerned persuade us not to resort to recall of all the degrees in engineering granted in pursuance of the said ex post facto approval. However, the facts remains that the facilities available at the study center concerns were never checked nor any inspection were conducted. It is not possible at this length of time to order any inspection, but there must be confidence and assurance.
Come to para
About it.
58. Come to para 58.
Yes, Lordship.
Which says 2 chances will be given.
2 chances were,
Yes.
were to be given.
So,
And Lordship, in paragraph 66, 66, Lordship, the whole issue was discussed and the direction were there. Lordship.
66.
Page 156, Lordship.
Yes.
Lordship, 66.1 it stated about the AICT regulation do not
Yes.
apply to the university. Deemed
Do
university.
apply.
Yes.
Yes.
Insofar as candidate enrolled during the academic season 2001, 2005, in the present case, the ex post facto approval granted by UGC and the authorities are set aside. Consent to aforesaid direction, all the degrees in engineering awarded by deemed to be university concerned stands suspended. AICT shall devise the modalities to conduct an appropriate test as indicated in para 58 above. The option be given to the student concerned whose degrees stand suspended by 15/1/2018 to appear at the test to be conducted in accordance with the direction in para 58 above. Students be given not more than 2 chances to clear test, and if they do not successfully clear the test,
So this is the direction.
this is the direction.
Yes.
And Lordship, later on, many of the institutions and the deemed to be universities approached the Honorable Apex Court with regard to this decision and sought for some clarification. That is in 2018 to SCC, Lordship.
There's a copy.
Page 2198.
Mm.
And the Lordship, relevant paragraph is paragraph 25304.
Mm.
We now turn to the general submission advanced by all the learned counsel that the candidates after securing the degree in engineering through distance education mode have advanced in careers and their ability was tested at various levels. And as such, a requirement of passing the examination in terms of the judgment be dispensed with in their case. We cannot make any such exception. The infirmity in their degree is basic and fundamental and cannot be whisked away. At the same time, we find some force in their submission that if the suspension of the degree and all advantages were to apply as indicated in the judgment, the candidate concerned
Come
may
to
look-
para 26.2.
Yes.
That is what is relevant for you.
Yes, Lordship.
Mm.
We therefore, as one-time relaxation in favor of those candidates who were enrolled during the academic year 2001-2005 and who in terms of the judgment are eligible to appear at the test to be conducted by AICT direct. All such candidates who is to appear in the forthcoming test to be conducted by the AICT.
So in terms of the original judgment, the some modification is that first attempt clearance, there will be no break.
Yes.
Will continue as such.
Yes.
But the second attempt, then the directions given for suspension of degrees, taking away of advantages, that will come to force.
Yes, Lordship.
That will be revived.
Yes, and that will be, and in this case, Lordship, the petitioners,
Yes.
writ petitioners, they appeared in the validation examination in the month of December. Lordship, the validation certificate is there, page 179 of the memo.
179. Yes. Mm. Yes.
Lordship, the first one, Lordship will see at the third line. Special theory and practical examination conducted during December 16 to 19, 2018. for validation of his or her civil engineering degree awarded by Institute of Advanced Studies in Education, Rajasthan.
So
Lordship, we are not against their degree because it got
they
validated.
cleared in
their-
first attempt, all of them?
They, as per their submission, they have not appeared in the first attempt.
They have not appeared.
Appeared in the first exam.
So the first exam was held to be held in 18 only, as per
May-
the Supreme Court
Lordship,
judgment.
two exams. One was held in May, another one was held in December. If they pass out in the first attempt, they will continue to have the advantages.
Yes.
If they fail or
So as per the pleadings, this was their second attempt?
second and only, they appeared in the second test,
second
but
attempt
only first time they appeared.
First time they either did not appear or chose not to
Choose
appear
not to
in the
appear.
first test.
Yes,
First.
Lordship.
Okay. Now, now what is the effect thereof? How it has been dealt with by the learned single judge?
Lordship, the clarificatory order was not taken into
Not
account.
considered.
Yes, Lordship.
Okay, okay. But what is the date of the clarificatory order?
22/1/2018. Yes, ma'am.
So that was in force. What do you say, Mr. Nair? Yes.
My lord, this as a checkered history, we came up before this, my lord, episode before the Supreme Court. We came up before this honorable court because we were not being promoted even after the degree. There were consented orders, which the department also consented to. And accordingly, my lord, directions were issued by this honorable court for our promotion. Accordingly, selections were held. And in 2017, a select list was published. Now, before, my lord, that select list could be converted, the Supreme Court, the matters got. So they waited, my lord.
Yes.
Then the first judgment comes. My lord, in 2018,
Yes.
which my lord has taken. I'll just, my lord, have my lord's attention back to page 57, my lord. Para 57, 153, my lord.
Yes.
My lord, just near placitum D, my lord. My lord has gone through the other rest. I'll not trouble your lordship. Just above placitum D, the line, we therefore deem it proper, appropriate to grant some chance to the students concerned to have their ability tested by the higher authorities competent in that behalf. We therefore direct that all degrees in engineering granted to students who were enrolled during the academic years 2001 to 2005 shall stand suspended till they pass such examination under the joint supervision of the AICT/UGC in the manner indicated hereinafter. Further, every single advantage on the basis of that degree shall also stand suspended. Then, my lord, after just a few lines after placitum F, my lord, not more than 2 chances be given to the students concerned, and if they do not pass the test, their degrees shall stand recalled and cancelled. If a particular student does not wish to appear in the test, the entire money will be deposited. Now, this was concluded in paragraph 66, my lord. My lord has seen the other paragraph. I'll only have my lord's attention at para 66.6, my lord. If the students clear the tests, both, within the stipulated time, all the advantages, benefits shall be restored to them and their degrees will stand revived fully. Now, what had
So
happened?
either in the first attempt or the second attempt, if you clear the test, the position will be ex post facto.
Lordship. Now, my lord, what had happened? This clarificatory order, which came in the in 2018 2 SSC, there were candidates, my lord, not like us, who were in service. They were, because we were in service, we were seeking a promotion. There were candidates, my lord, who had entered into service with this degree. Now, by this order, my lord, by withdrawing that degree, their very service was gone, my lord. So they preferred an application before the honorable court, saying that this is gone, our services
will go.
So the honorable court, my lord, in that context, my lord, gave this clarification. Because till that time, we were not having any benefit because we were not promoted. It's the degree doubted. That's why the select list was not implemented.
Okay.
Now, my lord would have that in
But
the
your appointment as such was never in question.
No, my lord.
Never
My
in
appointment did not occasion because in the sorry, my lord, my promotion did not in occasion. My appointment as a junior engineer was never in question.
Okay.
My promotion was, my lord, in doubt. And that select list, my lord, was published, but that was not given effective because of these proceedings.
Okay.
Now, my lord, would have the paragraph 3 of that 2018 2 SSC 298.
Clarification.
Clarification.
Yes.
Para 2, my lord. The applicants holding diplomas in engineering enrolled themselves in 2005 in courses leading to B.Tech degree offered by deemed to be universities in question through distance enrollment. Later on the basis of the degrees awarded by the deemed university, they underwent independent selection undertaken by the UPSC and entered in certain services as direct recruits and have presently either been engaged in the same service or have advanced in career on the basis of such selection by UPSC. So-and-so submitted that the controversy in the judgment was principally concerning the cases of in-service candidates who were initially employed as diploma engineers, but while in service had awarded degrees in engineer by the deemed to be universities in question through distance learning mode. And this court was not called upon to consider where such degrees themselves became the foundation for a subsequent employment or selection and further advancement in career. He further submitted that an exception was made in favor of such candidates whose qualifications were independently considered by an authority such as so-and-so and were selected through competitive selection process. And in any case, even if the judgment were to apply to such candidates, the suspension of their degrees and all advantages flowing therefrom till they pass the test as indicated in the ought not to be insisted upon. He submitted that unlike in-service candidates who may not be losing their jobs, such candidates who had independently undergone fresh selection and were directly appointed would lose their jobs completely. And if they were to successfully pass the test conducted by ICT, restoration of their original position and jobs would itself become a difficult proposition. Now, on the basis of this, paragraph 26, my lord Woods. 25, my lord.
Yes.
We now turn to the general submission advanced by the learned councils that the candidates, after securing the degrees in engineering through distance education mode, have advanced in career and their ability was tested at various levels, and such requirement of passing the examination in terms of the judgment be dispensed with in their case. We cannot make any such exemption. The infinity in the degree is basic, fundamental, and cannot be wished away. At the same time, we find some force in their submission that if the suspension of their degrees and all advantages were to apply as indicated in the judgment, the candidates concerned may lose their jobs even if they were to successfully pass the test. Restoration of their jobs and present position would pose some difficulty. It is in this context, my lord, that para 26 directions were issued. In our case, that's what exactly the Honorable Single Judge said, my lord. In our case, the select list was there and that was in pursuance to a consented order. But that was not implemented. Then, my lord, when this episode was over, they were not applying that. That's why we came up before the Honorable Single Judge. And, my lord, this Honorable
After
Court,
clearing your case,
cleared, my lord.
then you approach the single judge
Then I approached the single
to
judge.
seek a direction for operation of the
Select list, my lord.
of promotions.
Promotion, because the Honorable Supreme Court in that order had kept it under suspended ammunition until we clear that X. First exam, my lord, there was a wrong instruction given, they did not appear. But in the second they appeared and they all cleared, my lord. And in the department itself, wherever people have been clearing the second, they have also accommodated them. But in our case, my lord, from that list, half of them who had cleared the first examinations were, my lord, appointed, but we were left out. So we came up before this Honorable Court. And during the pendency of the proceedings, my lord, in the writ appeal, because there was no stay order, my lord, they have promoted us from that select list.
No, if that was subject to
my lord,
outcome.
finally subject to outcome of the, but we have been promoted.
Maybe what do you say? There is a distinction. This clarification was passed only in reference to those candidates who were fresh selected candidates.
No,
There was a risk, very risk on their jobs.
Lordship, but it's still maintained that the advantage on the basis of that degree. His advantage, the repetition advantage.
Their jobs are not going, na?
No,
their jobs are not going.
they were initially appointed as junior engineers, having diploma holder.
Their appointments were not in question.
But they're on
You did not seek to cancel their appointments because of this judgment of Supreme Court.
No, Lordship.
Did you give them a notice that clear or otherwise your jobs will be taken away?
No, Lordship.
It's a question of promotion.
Lordship, promotion, but they were after the this honorable court's orders. They were rightly assessed and there was a select list. In the meantime, the apex court decision came.
We understand, but you have to read this clarification in the context in which it was filed.
No, Lordship, it states that both, Lordship, in the context of those who were after getting the degree in through distance education, they were appointed some. Those were tend to be, lose their jobs. They are going to lose it. But it maintained the service.
Herein, there is no issue of them losing their jobs.
Yes, Lordship, only that
the implementation part, Lordship, that it cannot be from 2000 on the basis of the 2017 selection. Whatever promotion they will be entitled, Lordship, it will be subsequent to the passing of the validation test.
Let's see the beginning of the judgment. Who are the applicants?
My lord, in that second one.
Para 2.
Para 2, yes. Stay. My lord, the applicants holding diploma para 2, my lord, in engineering enrolled themselves in 2005 in courses leading to B.Tech degree offered by deemed to be universities in question through distance learning mode. Later on the basis of the degrees awarded by the deemed to be universities, they underwent independent selection undertaken by the Union Public Service Commission and entered certain services as direct recruits and have presently either been engaged in the same service or have advanced in career on the basis of such selection by UPSC. No. My lord, here the degree that was there from, my lord, any institute of distance learning mode, taking that they had entered into service. And because of para 57 and para 66 of the first judgment, their services were to be terminated.
The cases which were earlier considered, they were of diploma holders.
Diploma in service candidates.
In service
candidate. Because that's clearly in the next paragraph, my lord would say. That was the parity they were seeking. My lord. And this honorable court in para 26, my lord, in that context said, this should not be done.
Lordship, the paragraph 4 and 5 will also, because of different institute.
Paragraph 4 and 5 of clarification.
The second clarification.
Yes, read.
The those case numbers have been given. Lordship, the applicants have completed B.Tech courses in computer science to distance education mode. According to them, institutions were imparted in ITM International and they were awarding degree by Allahabad so-and-so deemed to be university. Later, they acquired degree in MTech and other qualifications based on such B.Tech degree and have thereafter advancing career. Lordship, it's an in-service. Lordship. MS Meenakshi Arora, learned senior advocate, while adopting the submission of Mr. B. Giri, learned senior, was submitted that ITM International is an institution of repute and no infirmity can be attributed further. Her clients in any case had undergone further selection process where knowledge of the candidate was independently tested and they were appointed in other posts. The candidates had acquired first degree in engineering from a regular and approved institution, and as such, their first degrees are not invalid or irregular on any count.
No, read para 8.
Yes, Michael.
Para 8 will
the applicants were awarded diplomas in engineering through distance education mode by the deemed to be universities.
So their initial degree, that was by itself invalid. That was the reason. Herein, that is not the situation. So in order to give them a saving grace that you will not be thrown out of the job, that is why this arrangement was made.
Yes, but simultaneously, Lordship, those second attempt issue was also dealt with. Because
it was only for those candidates, sir.
No, Lordship, in my humble understanding,
does this clarification dilute the rights of which were decided, rights and liabilities which were decided earlier? Does it modify the judgment? Let's see the clarification. Does it modify the original directions?
Yes, Lord. Paragraph 25.
Yes, read. Read. What it says about the original judgment.
Yes.
Yes.
We now turn to the general submission advanced by all the learned counsel that the candidates after securing the degrees in engineering through distance education mode have advanced in career and that their ability was tested at various levels and as such requirement of passing the examination in terms of the judgment we dispense with in their case. We cannot make any such exception.
Yes.
The infirmity in their degree is basic and fundamental and cannot be whisked away. At the same time, we find some force in their submission that if the suspension of the degree and all advantages were to apply as indicated in the judgment, the candidate concerned may lose their job and even if they were to successfully pass the test, restoration of the job and present position would pose some difficulty. We therefore, as one-time relaxation in favor of those candidates who were
So
enrolled
come
during
to
the
26.2. As per you, they will be covered by 26.2. Read. But if they fail to choose or not to appear,
Yes.
the directions in the judgment shall apply. So judgment means the original judgment.
Yes, Lord.
Now come to the original judgment. That talks of 2 attempts. Doesn't say that the candidate not appearing in the first attempt will also face that rigor. Read.
66.6. Final.
If the students clear the test,
Lordship.
public tests,
66.156 page. That will appeal.
if they do not, 66.4 also read.
Lordship. AICT shall devise the modalities to conduct an appropriate test and indicate in para the option to be given to candidate concerned whose degree stands suspended to appear at the test to be conducted in accordance with para 58 above. Students be given not more than 2 chances to clear the test, and if they do not successfully clear the test within the stipulated time, their degree shall stand cancelled and all advantages shall stand withdrawn as stated in para 57 and 58 above. So and so will be done. Then, my lord, 66.6, if the students clear the test
Public tests in the
within
stipulated time,
all the
advantages, benefits shall be
restored
restored to them.
and the degree
So this
shall-
is a case of restoration
restoration. Because it was, my
on
lord,
clearing the second attempt. Are we clear, Mr. Chaudhary?
Lordship, give me one chance. Lordship, I'll try to next week. Lordship.
Chance means what?
Lordship, there is another judgment, Lordship, that I could, it was in 2019, Lordship. In a contempt matter by the apex court, it clarified further, Lordship.
Then why did you open the arguments if you're not prepared?
No,
Taken half an hour of this court's time.
then I leave it to your Lordship.
We didn't force you to argue
No,
the matter.
just, Lordship.
After arguing, when you're faced with some adverse opinion, then
I'm just trying to clarify before this.
we are hearing you to the heart's content. As long as you want to argue. But having argued, then you take an about turn, U-turn, say, no, sir, no,
Lordship,
please give it time.
I shouldn't make any wrong submission before this honorable.
We are
So
not
that's why,
even,
Lordship,
we are not commenting on your submissions, the correctness or wrongness thereof. But the issue is that after arguing the matter,
because let's say in 2019, Lordship, I'll try to get it, get the citation number, Lordship, I'll give it. It stated that, Lordship may take that into account, Lordship. It stated that whatever advantage it was not there on the date of the judgment, that first one, Lordship. Here, Lordship, they will not be entitled, and whatever advantage on the basis of the earlier degree, they were selected and placed in the select list.
see, their original selection in the department is not under question.
That
It's a matter of
that
promotion.
advantage, Lordship, on the basis of that degree.
Yes, so they got promoted.
No, Lordship, subsequently it got validated in the month of
So they,
December.
on the basis
But
of
the placement in the select list, Lordship.
Just
that
the select list is for what purpose? For selection as
for
promotion as assistant engineer
executive-
from junior engineers
Yes.
on acquiring a particular qualification.
Yes, Lord.
That is engineering degree. They were diploma holders appointed as JNs. There is no irregularity in that.
No.
Nothing. So now they claim promotion on the basis of degree obtained from a distant learning course. To validate that, the Supreme Court gave them 2 chances. They cleared the chance, cleared the degree or the second chance. And the consequence in 66.6 is clear that if they clear it, the test, oblique tests, the position is restored ex post facto ante.
Yeah.
What more is required?
And the department, my lord, has been giving promotion to person similar like that.
Lordship, all those second, they will get subsequently, not because in the.
Have you placed on record any order which says that persons who have cleared on the second attempt, we have deferred their promotion?
No, Lordship, till the decision of the apex court, Lordship, only there was the 2017 selected. Thereafter, the selection process, whenever it started, all those who in the meantime passed out the validation, they were taken into consideration.
Okay, very well. Arguments heard order, sir.
Lordship, I will try to give that 2019 judgment citation number.
Mr. Nair, do you have that judgment he is talking about?
In judgment, my lord.
Let's
My lord,
rush it out right now. Yes,
I'll just
get that judgment. If there is anything to the contrary,
Lordship,
let it be cleared right now.
Lordship, my lord will take it up after 2 items.
Yes, yes.
Item number 34.
Make a condition. Lordship, I'm appearing on behalf of Somua, Council for UGC.
On behalf of
Somua,
Huh.
Council for UGC, Lordship.
UGC.
Lordship.
Yes.
Respondent number 5.
Hmm.
Lordship, he is out of town. And Lordship, we need some time to file our affidavit. And
Affidavit now in writ appeal. Didn't you file it in the writ petition?
no, Lordship.
It was not filed, but my lord, they made a stand that the UGC guidelines are mandatory.
That's
has been
the
recorded
law of the
by
land now, otherwise also.
That is the issue to be determined, my lord, whether the UGC regulations are, my lord, mandatorily followed or not. That is the issue before your law.
Then Lordship, otherwise also Lordship, on the basis of that particular interview, Lordship, already 693 candidates were appointed, Lordship. So Lordship, they are
On the basis of
on the basis of that particular advertisement, Lordship.
693
was already appointed, they have joined and they is continued.
they've joined. Now they've challenged what?
No, Lordship.
We have challenged
Petitioner have challenged, Lordship, but that challenge.
Let Mr. Chaudhary state.
Lordship.
You know, Mr. Counsel,
Lordship.
there's a propriety that when a senior advocate starts addressing, no one else is supposed to interfere. Okay. So you have to learn that etiquette at least. Yes, please.
My lord, the writ petitioners approach this honorable single judge, making a grievance against the notification of the state government by which the selection guidelines for assistant professors were issued. The grievance of the petitioner was that the said guidelines, although followed the UGC regulations in respect of eligibility conditions, but in respect of distribution of marks, that has not been followed.
Not been followed. Okay.
And the claim was that in the appointments to be made, selections to be made, that has to be followed. That is mandatory. That was the submission. And it's not that matter one particular advertisement was challenged, because my lord, advertisements keep on coming and going. More than 800 persons have been appointed. My lord, I have brought on record by way of additional affidavit. And the honorable single judge has given a finding, which my lord, I will try to satisfy your lordship that is wrong, that the regulation of 2010 was not completely adopted.
Okay.
Only a part of it has been adopted, which is wrong, my lord. In fact, the finding, if your lordship may come to the interim judgment.
Mr. Chaudhary, before we proceed to that,
my lord,
would the selection of that number of candidates, would it have any impact on your claim?
No, my lord, because
there are still posts are lying vacant.
It will be, my lord, future vacancies only, my lord.
Okay, okay, very well.
I have not challenged anyone's, my lord, appointment.
Okay, you as a principal, you are coming out.
My lord.
Okay, then let the UGC file its affidavit. We'll give them one chance. It is stated
that stand has that has been recorded by the honorable single judge, my lord. That was submitted. That the UGC. In fact, my lord, I have brought on record one subsequent, my lord, notification of the UGC by way of additional affidavit that has come only now, which my lord specifically states that the UGC guidelines are mandatory.
Mandatory.
Followed. That is the only issue to be determined.
So if the UGC does file an affidavit, it will further strengthen your case, we suppose. Then counsel MS appearing for standing counsel UGC, submits that the learned counsel is not available today, and that some time is needed to file an affidavit on behalf of the UGC. Though we feel that though we find that no affidavit was filed by on behalf of the UGC in the writ petition, in the interest of justice, one opportunity is granted to the UGC for filing an affidavit in this writ appeal. List after 6 weeks.
A little bit shorter time.
It will not be possible now, sir. They're already facing this on setting summer vacation now.
Short issue, my lord.
List on 18th July. The affidavit shall be filed positively before the next date. List on 18th July.
Item number 35.
As per my lord's direction, it should be go to the education special bench.
Okay.
My lord.
Provincialization.
Yes, my lord, the particular provision of the statute virus is challenged.
So, Please before the special bench be constituted for hearing matters relating to provincialization.
Obliged.
Item number 33.
Could you find it, Mr. Nair?
2019, 8 SSC 280.
Call Mr. Chaudhary.
4 minutes. 4 minutes. Nineteen, 280.
What is the proposition in this judgment?
It's my lord a contempt petition. And the petitioners therein had also passed in the first attempt, my lord.
Restoration of status quo ante upon satisfaction of the
First
conditions
condition.
laid therein.
Lordship.
So they sought additional advantages.
That
in the
was not
contempt.
given, my lord.
Still read the judgment.
I'll
If there's
read it.
anything relevant,
Lordship, my lord, matters.
no more matters.
No, my lord.
Don't worry, you just read it.
My
Take
lord,
it.
I'll just have 2 minutes, my lord. I'll just.
Yeah, sure. Let Mr. Chaudhary come in the meantime.
Lordship. The conclusions start from, my lord, paragraph 3.3, my lord, the so and so. I should 2019.
Lordship, can you take up paragraph 12 and 13? If it is
Yes.
2019 8 SCC 2.
Yes.
Paragraph 13, Lordship. Some candidates approach this court submitting that if in terms of the judgment one, the benefits of advantages were to be withdrawn and could be restored only after the candidate has cleared the examination, it may entail some prejudice to the candidate. Some of the candidates who had obtained postgraduate degree and were employed on the strength of such degree will be required to surrender such benefit, and even if they to pass examination in the first attempt, it may still require restoration of the benefit, leading to situation of inconvenience and prejudice. The direction in the judgment will therefore modified to a certain extent in order. It was therefore laid down by way of further concession in the order that all the candidates who desired to appear in the upcoming examination could retain.
Read
all-
para 14, that would make it clear.
It was therefore clear.
It was therefore clear that the candidates who on the strength of such degrees awarded through distant learning or had attained a particular level in their career. So they had not attained anything.
No.
They were then only that.
They had appeared in the selection process. But this restoration of the status quo ante that has been affirmed in this code. Read para 15. Thus, the intent was to restore status quo ante and not to confer any additional advantage by this judgment and the order.
So it's that only.
That would make things more clear, Mr. Chaudhary. It was not the idea to hold the candidates to be entitled to certain additional benefits, which the candidates were, as a matter of fact, not even enjoying on the date of the judgment. If the degrees stood restored in terms of the directions in of the judgment. So that is number one.
Number one. Lordship.
And the order. So both
Modified.
inclusive. So they are covered by the judgment.
Lordship.
Two attempts. The candidates would certainly be eligible to such entitlements, but restoration would only be of those benefits which they were enjoying as on the date of the judgment.
Lordship.
So they were enjoying, they had been selected. So that has been restored.
But Lordship, 13 paragraph says it's not with regard to the particular sections of students who approach the
That was
in clarification.
Order. So order was in relation to those people who were initially selected on the basis of these degrees.
But here only the advantage is only placement in the select list. Lordship.
Yes, that's it.
That's enough. My humble understanding.
Of course,
that they will not be-
your submission will take.
That select list that was there, that was kept in suspended admission by the Supreme Court. In para 57 last line, my lord. And that with the passing, it got opened. And if I had come with that degree and got the service, then the second order would
Then
come in
the
and this
second
would
order
have.
would be relevant. Wherein he had to clear it in the first attempt or else go home.
And the, my lord, the thing was.
Because
And then also it would not have been go home. Still a second chance was there, but then the degree would remain suspended.
Suspended. But
So
my
the
lord,
suspension of the degree was stayed for first timers who had got the job on the
with
basis
that
thereof
degree,
till they cleared the first attempt.
Lordship.
That's all.
That was a benefit given, who were enjoying with that service with that. degree.
Enjoying service on that count.
We couldn't commit, my lord. And that select list was prepared. my lord,
Had the promotion been declared
Then it would have.
on the basis of select list, probably they would have
Lordship, the promotion was not declared. In the meantime, the first judgment came.
judgment.
First judgment came.
And therein it was suspended.
Yes.
That was restored.
That was not there, Lordship. There was no
66.6, was it?
Yeah.
57 last line.
Chaudhary is not satisfied.
Lordship, with him, I get.
He's my batchman. We studied from nursery to.
We can quite see the congeniality in you, both of you. Okay, thank you.
Much obliged.
We'll have something, Lordship, on the outside.
Oh, yes.